My lord, various things has happened, my lord. A very unfortunate. First, I apologize, my lord, for not being present yesterday.
No, that is not.
My lord, I was supposed to come here, my lord. This is the ticket by 7:30 flight. It got
No, no,
delayed.
we understand this.
My lord, the difficulty is, my lord, I had asked for a VC link. They said that it cannot be provided. Because now, after Supreme Court decision, VC link can be given. Because I didn't want your lordship court to wait. So I wanted to do it online. And thereafter, if your lordship feels that it will be taken up on a further date. My lord, that was not, my lord. Furthermore, the CBI said that before 28, he will not be free, he will be otherwise any. He had a talk with me because over phone, I had a talk. Because I wanted to do it today.
We have passed an order.
I know,
That
my
we
lord.
cannot recall now.
My lord, I know that. My lord, can that matter be there on 28th? I'm not.
How can I pass an order now that has gone out of my chamber?
Now, what is the way out, my lord? Because your lordship has heard it, it's at the fag end. Only maybe in half an hour, 45 minutes,
No.
the matter would be concluded.
See, there is a procedure. See, I am taking a bench trick. Had it been a criminal bench, it's different. A matter is being parted for long.
My lord,
Now,
the only difficulty, my lord, on the last occasion also, my
you
lord,
do
since your
before
lord,
the appropriate point. When you are having a merit, it will be decided in the
but
time
the
of.
only thing it has to be done, Dino. That is the reason, my
We
lord.
are doing every day. We are dictating orders for whole day. At the end of the day, lawyer will seek time, will adjourn it. This is our experience. For us, it's not a new thing. Every day we are having.
My
So
lord,
we have passed an
if your
order.
lordship allows me, my lord, we can at least get the matter assigned to your lordship because of the fact that
No,
it was.
that cannot be. This is not my prerogative, number one. Number two is that once an order is passed, releasing from Parthard, it cannot be assigned to me without, it will go to the. Okay, next case.
Maybe.
Hmm.
Alert state maximum item for 25%.
Hmm.
Much obliged.
With consent of the other state, alert, I'm not.
In fact, madam, there was a series of criminal petitions, State of Assam preferred appeal. We were supposed to release it from Parthard. They also short time, last occasion also, we in fact dictated an additional advocate address it.
My lord,
Yeah,
actually,
this
I
is
was,
we do not, we treat
my lord,
everybody.
it's not that I wanted an accommodation
No,
yesterday. I only
he was there.
wanted a VC link. But my lord, they said that it has to be a 48 hours notice or else, my lord, it will not be provided. My lord,
That is the rule, High
my lord,
Court rule.
so my lord,
That is
I
I
was
cannot come and say.
watching your lordship live and my lord, things being submitted, but I couldn't actually help out. My lord.
Okay, next case.
Much obliged.
Item 25.
Huh?
Item 25. If in matter with consent of the other state, alert, I'm not keeping real, alert.
You have taken consent order.
Yes,
You are for a petitioner.
Right.
After 4 weeks.
Lordship, I beg to mention item number 2. Lordship, kindly pass over the matter for today. And maybe decide after 2 weeks.
Prayer for adjournment stands rejected. Yes, next.
8 weeks. 8 weeks.
Hmm.
But the beg to mention item number 2 is that in this matter, the PhD department has filed a affidavit in opposition asking. I need some time to file a rejoinder to file. I have taken the consent.
Okay. Rejoinder by the
Satisfied.
petition. 3 weeks. Item number? Joint Council, Mr. Kolita, A. Kolita, Council of Details submitted, meter has become interest. Full stop. Accordingly, petition stands closed, being in process.
I beg to mention item number 15, 16, and 18. Kindly, matter may be taken on hand. Right. 15, 16, and 18.
What happened?
Mr. I will argue this case about this on.
Okay, it is submitted that Mr. I.A. Saikya Learned Council, Learned Arguing Council is having personal difficulty as his son is hospitalized. Therefore, an adjournment is sought for. Prayer stands allowed. Is this matter?
Next.
After 2 weeks.
There is item আছে that is tag with along with
15, 16, huh? 15 and
15,
16?
16 and 18.
15, 16 and select separate order.
So there is another metamelon item number 55. That part that is the tag along with other case.
Uh-huh.
Our meta may hard
Item,
55.
where is 55?
It's a hearing
We don't have 55.
50 to lot.
Hmm.
But the item to 21.
Item number?
20.
Yes. You are for your name? Okay. Mr. P. Hazarika, Learned Council, appearing on behalf of Mr. P. Pathak, Learned Council, submits that the petitioner may be allowed to withdraw his writ petition. Prayer is allowed, his petitions can withdrawn. His petitions can close on withdrawn. No liberty.
Item
You are Mr. Mr. H. Agarwal, Learned Council, it is same comma. It has become imperfect.
Eight is before your lordship.
Yes.
Care-
Where is the affair? Learned Council for the petitioner, raised for an adjournment. Prayer stands allowed. When?
Lordship, so expert but
Please stop for a bit. Did you I get the admission not delivered? Yes, it's on this. Hmm? It was something.
Please, Lordship, the item may be passed over for some time.
43.
Yes. Obliged.
Bishop Market. By 2015 method.
Others have become attractive.
Right.
The appointments have been made, the similar registration in the same two matters has also been
This code.
by coordinate basis.
This code also, I think.
Perhaps this is 2013. I have the order.
Just let me see something different. What is the issue here? What is the prayer? Madam, 2015 method is difficult. We are trying to. It's not very difficult. It's very difficult. And therefore, we have issued a notification also. At least you should intimate date prior. These cases are being listed.
The date.
Where is the advertisement? WPC
At the
502, keep 502.
at at
Item 3, give item 3.
Page 26 is the right. The
Please,
26 is the right. And these repetitions pertain
Shivsagar.
to Shivsagar. The Shivsagar
So
electrical.
these are some all different still advertisement.
That was one composite advertisement for different electrical.
One composite this relates to
Item number 3 relates to Shivsagar.
so we are in item number 2, is not it?
This is I was looking at
502,
item number 3.
item number 3.
Yes.
Okay. It relates to Sahayak.
Category B.
So first category is ITI certificate.
But they are concerned with
No,
category B.
that is second is temporary workers engaged in power utility work as Sahaya.
It- or
Any power utility, engage in any power utility service. Okay. And educational qualification is HSLC. Okay, now what happened then?
they apply
Hmm. Hmm. Mike.
for they approach
Uh,
by
so why you approach earlier?
earlier they approach court
Hmm.
for allowing them to appear the
Okay.
court
Past and order.
allowing to appear
Where is that?
interview.
Page 70. Petitioners may be permitted to appear in the interview scheduled on 15/7/2015.
Yes.
Page 70.
72.
72.
Yes.
Okay. A similar order. 70 also
Yes.
similar.
Yes.
Under category B.
After appear
Such appearance subject to be, however, will be
yes.
outcome of the writ petition. No selection process. Selection was going on.
No, but they appear
Ah,
with the
What till now what we could understand is there is an advertisement. You will according to you, you are category B. You applied, but you were not called for the interview. Now you approach this court. Court says allow them to participate subject to outcome of the writ petition. Now what happened to that writ petition?
that what the that
You were allowed.
that's where that
Without your participation.
that so there
Uh,
after the
without leave of the
declare yes, without
Okay.
the-
Hmm.
Then in another occasion, the court allowed after request of the government after if
Hmm.
adjust if the result they have approached the court for declaring the result. So court allowed the eviction declare the result. But what happened they declared the result and there was order.
So provisional list was published on 12th of January.
Yes.
Hmm? Without leave, list was published at page 74. Isn't that it? Then what happened? Again, approach this court.
Yes, by way of this,
That is 4597. What is 4597?
459, that was similar, uh, similar,
Like this.
not this. Food, the food of
Okay, then what happened?
And those, uh, it- 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 this both, it- both, that on the ground that they produce the merit list of the exam.
Just a minute. 4078, there was a direction allowing you to appear and not to declare the result without leave of this court. Is not it? Now, according to you, list was published on list was published at 74 in violation of order at page 72. Isn't it? Now, what happened thereafter? So, you challenge the selection list, select list in this writ petition. What is the stand of the
But the tax benefit not participated
Hmm. did they participate?
in the participate. Now, the experience criteria and the certificates that they
No,
require.
whatever you have declared the result, leave was not taken.
Just take it out of that order may kindly be it's part of our affidavit in
No,
opposition.
no. What happened to 4078 and similar situated cases? That issues to be determined in that case, is that it? Not only 4078, 4078 so far related to its madam's case. There are some other case where Torun Chutia appeared is WPC 4002.
Yes, that's also both the
Subsequently. Why?
because my at that time my
Where is that order?
It's not. It is not. I also have
so that
Dispose of methods are there. Some dispose of methods are yes. 4002. 4002. There is a dispose of method 4002. In view of that, this bench, what will you determine in this case? You will have to
no matter though though it's please, at that I remember at that time of my the matter was the 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 it said that they produced this merit list and without giving the merit list by the board of the because the marks obtained by the petitioners were not I thought they did not come under their purview of the merit. That is why I not put this. And this and some of the petitioners again approached the honorable court
Hmm.
for filing a review petition. And in the review petition, and
My lord, court has observed that some marks were not given in the experience set matter. No marks were given in the experience for and the court of adopted.
Fine. So there was a permission to challenge the select list. Where is the challenge to the select list?
Detective matter that court has only been
No, no.
before filing
So far, what we have understood is now, up to now, let us summarize the facts. We'll go later on to the merit. There was a selection process for Sahaya. You come under Group B. Okay. You applied for that. Then you were not called for the interview. You approach this court. Court says, allow them to participate. Don't publish result without leave of this court. Okay. Despite that, they publishes a select. Okay. However, the earlier writ petition where leave was directed to be taken were closed for whatsoever reason. It was closed, but that leave was not taken, was not dealt with in this writ. That issue was not dealt. So matter ends there. Now, court says that okay, select list is published. These petitioners are far below the list, so we are not interfering. This is one. Second part, court observed that you have advertised 93 posts. However, you have made appointment so many posts. There is an passing comment that you could not have done this. This is one aspect of the matter. However, since these people are below, so we are not interfering. Petition state. So challenge to the select list that which is done here was negated in the writ petition on the ground that you are much below the cutoff or whatsoever. That ends there. Now somebody or you files a review saying that select list we have challenged cannot be given a certification without totally examining that selection process. More particularly, when we allege that there are anomalies in granting mark. Isn't it? So court says, okay, fine, because that select list was not a subject matter of that writ petition. Though you are below, now a liberty is given. Okay, fine, if you are still aggrieved that the select list was not properly done, you can challenge it. This is one aspect. Now, whether in this writ petition, the ground of challenge that you were not given marks or ground of challenge is that without leave of this court, list has been published.
Why the review petition was pending?
Ah.
Before that, it
This was immediately filed. Why immediately?
Filed, but that was filed earlier. When the provisional.
No, understand. Because the cause of action for this writ petition were that see, there is a specific order of High Court not to declare the result without leave. You have declared. How can you do this? This is one of the fundamental grounds. But that was not even dealt where the order was passed. So that interim order merged with the final order. Isn't it? So the ground of publication of list without leave of the court is now no more here, which is a ground in this writ petition. So therefore, the second questions come in the review. a permission was granted to challenge the select list on the ground of this additional ground that the whole selection process was vitiated for non-granting of marks in experience. That is not part of this writ petition.
Affidavit.
Hmm.
Those after this.
Okay. Now, thereafter, I think such writ petitions were challenged, such selections were challenged by another set of writ petition, wherein it was directed to have a committee.
Right.
Then committee given a report on the basis of that some other writ petitions were filed and those were negated.
That is with regard to 2008.
Okay. Now, therefore, who are for the private respondent? Selected candidate. Any selected candidates are party?
Yes,
Any-
my lord. It party. Both the
These three people were selected.
So far relating to Shiv Sagar.
from private respondent and item serial number minus 6 from 6, 7. or 57. But none has approved.
Service is complete.
Yes. At least some time
Yes, Gokul.
Again, one of the select list in question for the 20 has not been.
Hmm.
The engagement order and the select list that has not.
No, select list is changed. Tell it.
93 people were appointed. Some of them have. Now the appointment. So I may just state
No, according to them, these persons are wrongly selected. Others, they have no grievance. If these people are wrongly selected, if their selection goes, they will come into the zone of work. Might be that, might be the case. We do not know as on right now.
now.
What are your grounds in additional affidavit? Let us see. Additional affidavit.
that
Huh?
they have cited that
No, that grounds of challenge. Reply will not do. Reply to their decision. But whereas, see, primarily, you ought to have challenged this select list by bringing additional ground. Primarily, you ought to have filed a press writ petition challenging this. But since, okay, by additional affidavit, you can bring new grounds. Let us accept we are in a writ proceeding.
That there are judgments to that effect. Now that cannot be done.
Well, we can handle
Yes,
it.
yes,
We can handle it.
yes.
We are in a writ jurisdiction. We can handle it. But if the specific grounds are not there, how will they respond to it? Paragraph 5 of your reply. That is your reply, not a.
my lord.
Where is that additional affidavit? Additional affidavit filed on. There is no additional affidavit. Is there any additional affidavit? Okay, you go through it. We are taking it up on when? Most way? Monday? Nineteen.
No.
No, we cannot adjourn. This is 2015 matter.
My lord, of
20,
20,
What?
15.
28. Have the record of it.
Yes.
Also be ready with that ground. That
I do not
You
have a
will-
copy of it.
give a copy to additional. Okay. And others case, anybody file additional affidavit? No. Your cases are gone there. And yeah, you? Okay.
Right.
Are?
Harbor.
See, don't say all this when matter is of 2015. We have accommodated you for till next 28, 28, na? 20. We'll decide on that. We'll make a serious argument on bringing new grounds by way of an addition. We'll argue that that is not permissible. You ought to have filed a written. Because I think he is having a slippery case. Otherwise, he will not argue. If he is a good case on merit, he will not argue.
Otherwise, also on the point of experience, because they were not given marks because they did not qualify.
Okay,
Not
so
with the
show us that from the
No, no,
record.
I'll get.
Show us from the record. We'll do it on merit. Why should let us go to all those things and reject them? Be ready. Huh? Madam, don't seek adjournment. This is 2015. We are almost 2024. It's difficult. Okay. Though this matter is pending since 2025. However, as per Patra Gohai, Learned Council submit that he may be granted a little accommodation till till 28th of February. There is allowed. Please this matter on 20th. No further adjournment will be granted. Mr. Gogoi, Learned
He should
sorry, P. Chaudhuri, Learned Council for the FPDCL, shall be ready with a relevant selection, relevant record pertaining to the input selection. Hmm?
another
Who's your senior?
other
Let us start. You are having the brief. You go to your senior, bring the brief. Yes.
the P Nayak is also like kind of he
Let us see. Let us see. See, P. Nayak is having responsibility of many departments.
Yes.
You people are assisting him. Why you need P. Nayak?
oh, Lordship, because he was preparing in the morning, Lordship, because that is
Okay, let us start. Let us start. We'll see. Go and bring the brief. You will have to argue. Yes. What is the issue here? Talia, what is the issue here? Okay. Okay. A specific instruction request was made to.
Yes, sir. So,
Okay, let me. Non-appears but a petitioner on call.
Lordship, actually, this matter, perhaps the matter has become.
Not perhaps, it has become in fact. What perhaps? What was the last order?
Last order was not to make any such respondent was directed not
To consider your case, they might have considered. This is a matter pending since 2017.
in fact,
It's-
already promoted. New promotional lawsuit.
So there is no question. The learned counsel for the petitioner submits that this matter has become infructuous. Full stop. Learned standing counsel for the irrigation department submits that pursuant to this court's order dated 4/9/2019, the petitioner has already been promoted.
First promotional law.
Already been promoted by an order of by an office order dated 18th of September 2019. Full stop. A copy of the said order is also produced before this court. In view of the aforesaid, this petition has become infructuous. Accordingly, same stands closed in infructuous. Same being closed. Full stop. A copy of the order dated 18th of September 2019 is kept on record and marked as document X. के नाम के लिखिएगा प्रोफाइल में। Yes, Mr. Saliha.
I have kept my instruction, my lord, soft copy, my lord.
Mm.
His name was considered and rejected on 23/8/2018. PP says rejected.
Give a copy.
I will print out and give it to him.
Okay. This court, under its order dated 6/12/2023, 6/12/2023, comma, and 15/12/2023, requested Mr. S. Bora, learned standing counsel for the requested Mr. S. Bora, learned standing counsel for the respondent BTC to obtain instruction whether the Joint Director, Health Services, Kokrajhar, has received the family status report of the petitioner from the Circle Officer, Datma Revenue Circle, and if received, whether the case of the petitioner was sent to district level committee for consideration of her case on compassionate ground. Full stop. On instruction, Mr. S. Bora submits that the case of the petitioner was placed before the district level selection committee on compassionate appointment of the district of Kokrajhar.
No. It will be a 4 district.
Okay.
One
Before the committee, not necessarily on
on 23/8/18.
23/8/18, and the case of the petitioner has been rejected. A copy of such what is this communication? Minute is also produced before this court. If to his, he will give a printout, produce. A copy of same be furnished to Mr. I. Ahmed, learned counsel, assisting Mr. P.P. Saliha, learned senior counsel, so that the petitioner, if so advised, can challenge such order. In view of the consideration and rejection of the case of the petitioner, nothing survives in this petition. Accordingly, the petition stands closed. The minutes of meeting dated 2020 be kept on record and marked. This is how we can close. Because it was pending since 2018 on the ground that my case was not. Hey, take a copy from him, WhatsApp or whatever. Give a two printout, one to him, one to him. Yes, Mr. Nath.
This is the petitioner was case 3 on my lord.
Mm.
In the administration for last 32 years.
Mm.
The same.
Mm.
It's for promotion to the post of my lord Lord President.
Mm.
The criteria is HSLC plus 5 years experience. For higher secondary 5 years and HSLC 7 years.
Who will represent the state?
I am
Affidavit file?
we have filed affidavit. FIR filed by the Director of Municipal Affairs.
I can take a lordship to my lord. Page number 20.
Where is that it's a promotional post or some
My lord, rules I can show you the.
established direct administration that
Yes, yes, yes.
Directorate of
Page
some
28.
ministerial service.
Yeah, we have quoted page 28. We have quoted the. Or in the book also, lordship, I think.
Where is the schedule? This is
No, it
municipal
is mentioned
administration.
there. Yes. Great course service is there.
No, no. Where is the schedule that municipal administration is undertaken?
Yes, the rule is there. It-
Hmm?
Then see my.
Hmm?
Assam Director established Ministerial Service Rules.
Just a minute. Ultimate.
This lordship will find will tell you at page number 20, the director writes the commissioner secretary to the urban development file. Page number 20. Let's make it clear. Right? The next step. Dated 27th of October 05. I have the also got
Just a minute. Just a minute. Where is that municipal? You are appointed as
my lord as the peon, my lord. Lordship will find that in page number, my lord, 17. Or I have been confirmed, my lord. That's also.
Assam Directorate Establishment Ministerial Service Rule
Yes.
in terms of rule sub rule 2 of rule 1 is not in the schedule. You come to rule 1 sub rule 2 of the give the book. Short title commencement of the act and rule 2 sub rule 2.
Two, sub-rule 2, my lord.
Yes, read it.
Assam
Ministerial
Ministerial.
Service Rule 1973.
Sub-rule 2 of which rule, my lord? What's the
Sub rule 2 of rule 1 of Ministerial Service Rule.
rule 1? Fine.
Yes.
These suits can be applicable to the administrative staff of the office of the head of the department from column 1, comment contractor time payment.
Comment column 1 of the schedule 1.
Column schedule 1.
Okay, if you go to column 1 of schedule 1, your department is not there.
But it is the publications, their public time
No, no, just we'll go to that first.
Yes.
First of all is that when you are seeking a right of promotion from grade 4 to LDA,
Yes.
in terms of ministerial administration rule, where there is a prescription of some percentage, 25% or something like that,
Yes,
and some
yes.
qualifications, some
Yes,
experience.
my-
That rule is made applicable in the schedule.
yes.
In the schedule, your department is not there.
Yes. It is
If
not-
not there, this is not applicable. Now you'll have to give your right from some other rule.
Now let us see from the other angle, my lord, from their own documents, let us. From their document. Department's document.
So this rule is gone. For the
For the
time,
timing,
in
let
terms,
it
in
go.
terms of the
Yes.
rule.
Yes. For the timing, let us keep it as that.
Okay.
Okay. Now, my lordship, please come to page number 20, my lord. Thank you. Page number 20. October 2005. This is by the
Page
time.
20,
Page
20.
27th October 2005. I have the honor to state that consequent upon promotion to the post of register as well as two posts of assistant superintendent as approved by the government, 3 numbers of EP assistant will fall vacant to which 3 LTS will be promoted. Consequent upon promotion of 3 LTS to the post of QTS, 3 numbers of LTS vacancies will arise. In keeping with the increase of workload, these posts are to be filled up very urgent. The procedure for direct recruitment to the post LTA from applicant having minimum qualification of HSL examination passed as per ministerial service rule applicable for head of the department, that is this department or their my lord.
Their interpretation will not do.
I said, let us,
If rule says not applicable, it's not applicable. Can an officer say it is applicable?
my lord, it is there. My lord,
If it is there, show us.
yes, yes.
That's why I
It is
said that
Serial 52.
fundamental question is this is made applicable.
Yes.
Officer's statement
Okay,
will not
that's
go.
right.
Will go by the rule. Where
My
is the
lord,
schedule? That is what I
52,
first.
Director of Municipal Administration,
Where is that schedule?
serial 52. If you
Serial
52, my lord, that municipal department is there. Schedule 1, CTL 52. Last page of the
Okay. Tell us that.
procedure of the number. Guidelines stated. Date for employee having 7 years of service.
So now your officer's communication is having no relief. You have a right under the rule.
That
Suppose there is, if your department is not in the
email
schedule,
on I got a right.
whosoever says,
Yes. Yes.
more they may do it, but courts of law will see whether you have a right
That is
and a statutory or something
And
else
right
so
to be
that.
considered is a test of the fundamental right
Yeah.
of previous health judge,
Yeah.
gave the judgment by the
Yeah.
my lord. So clear point. Now my lord,
Now let us come to the fact. Now we are satisfied that
Yes.
this rule is
Legal.
applicable.
Yes.
You have a legal right. Now how that has been violated. Now let us understand your facts.
my lord, now lordship will find
Hmm.
page number, my lord, 17. Page number 17 first, his appointment. Second paragraph. Third paragraph.
Page
Page 17, annexure 1. That is the year 1992, 8th of January. Subject to discharge without notice and without assigning any reason thereof, the Baharul Islam, who is working as peon against deep vacancy in the directorate,
page 17.
page 17. Last para, third para. Peon. He was working against the leader to vacancy. In page number 33, this service has been confirmed. In 27th of November 2013.
Page 30.
33. 30. There are other persons also like him, 7 persons, all of them have been confirmed in their post. Nursery, driver, peon.
Your name is
Baharul.
Baharul. So your service is confirmed on
27, my lord. 30th page number. On 27th November 30.
27,
November
11, 13. Now, what is your promotion? You have been promoted.
No, till from that day till today, 32 years.
Hmm.
Same file I am going from one room to another room. That's my duty.
You have been promoted from Priyam to,
It's not promotion, my lord. Beyond this.
okay.
Same.
Okay, now what is
Now
your,
page number 21, 20, Lordship is seen, my lord. I
Hmm.
just want to show one thing, my lord.
Hmm.
Page 20, Lordship is it. Please come to page number, my lord, 21.
Hmm.
Second part of this letter. In view of minimum urgency for filling up all the posts of LDS, it has been proposed to promote the existing T number of grade 4 whose service have been exceeded more than 7 years and qualified as per rule.
how can you do that?
Page
How can they deprive the other persons who are roaming in the street waiting for an advertisement to be
No, no.
made?
So, maybe quota, because there is another quota. There are 8 posts also. There are 8 posts.
Hmm.
2 posts promotional posts, 6 posts direct posts. Which is there?
Huh.
It is there in the help. There is a page 37 also will find.
Okay, now
page
what is your stand?
My lord, there are 10, my lord, let me say, my lord, before my let me start, my lord, let me contest and repeat one thing.
If
I
you-
received their affidavit.
Hmm.
In the affidavit in paragraph 8, my lord,
Hmm.
one statement they have given, my lord.
Hmm.
That statement is that, my lord, kindly have a look, my lord, that I have
Space.
page number, my lord, paragraph, page number 72. Page 8. I'll argue on his behalf, my lord, this part, my lord.
Paragraph?
Page 72, affidavit. Second part. In the entire statements, they say it all matter of record, my lord. Only this is one statement I find. The further deponent begs to state that petitioner had submitted an application dated 27/1/16 to the Dadan Director Municipal Administration for promotion to the post of LDA.
No. Which paragraph?
Paragraph 8, page 72.
That as regards the
As a statement made in paragraph 8, 9 to 12 for the petition matter of record and deponent does not admit anything which is not borne out of record. The entire statement is mine, my lord. In the affidavit, you will still find this. Only the change is further. The deponent begs to state that the petitioner had submitted an application dated 27/1/16 to the Dadan Director Municipal Administration for promotion to the post of LDA, but the petitioner has withdrawn his application.
Now, what is the present position?
We still were the same. Now, present position is qualification has been enhanced.
But where
From
vacancy
2016, from
vacancy
2016.
relates to which year?
So, vacancies 2050 onward.
Suppose a person qualifies for promotion on this date, on a X date. Now, from on X date, he has qualified, vacancies were there. His case is not considered. The rule is amended
This is the
subsequently.
judgment.
Rule is
Okay, so-
amended. Rule is amended.
Subsequently,
His will have cases will have to be considered.
So, before amending this rule, there was no proposal for promotion. But they proposed it, but the finance department they did not approve. That's why he individually he withdrew it 2016. Now on 2015 onward, we have enacted the amended rule. So to kindly see page 87, annexure G, our affidavit. So he is not qualified as per this amendment rule. There was no process for filling in the post where he was qualified. 27 September 2016, in exercise of the power conferred by the provision to Article 309 of the Constitution of India, Governor of Assam is hereby pleased to make the following rules. Further, to amend the Assam Director of Establishment Ministerial Service Rule 1973. So this rule shall be amended rule of 10. The principal rule in Rule 10, clause 1, for the existing
No,
service-
understand. Suppose if you see, promotion may not be right, but right for consideration is the some judgment. It says it's a valuable right. Even in some judgments, it says it's a fundamental right.
Yes.
So if it is a fundamental right, if vacancies were there,
Yes.
if a person is qualified, he has a right for consideration. If that right has been violated, we can issue a writ of mandamus for consideration, not
Yes.
for promotion.
Yes, yes.
Second part is, now second question comes, that in the meantime, the rule has been amended. And in terms of the new rule, they are not entitled for
Promotion.
promotion. So if they are not entitled for promotion, what will happen to a post which fell vacant on first condition, and on the date the vacancy arose, or till the post was filled up, till the amendment was given effect to, what will happen to that vacancy?
My lord, regarding these vacancies, my lord, there must be a initiation for promotion. Process should be started. But that process was not started because finance department did not.
So
follow
if
appropriate-
process is not started,
Not
it is a
started.
non-consideration of their right. If they are qualified, vacancies are there. It is not a non-consideration of their right.
No, my lord, that is to, my lord, the Supreme Court also say one.
Tell us.
Hold on. Service to the promotion respective date. And promotion takes effect from the date of from which it is granted and not from the date of offense of vacancy or creation of post.
No, that's fine. No problem on that.
So
No problem on that.
the petitioner was in debt.
Suppose you give a promotion him today on the basis of a vacancy which arose prior to the amendment of rule, subject to the condition that he was within the zone of consideration when the vacancy arose, or prior to amendment and he had the qualifying service or the eligibility criteria. Suppose you give him promotion today, you will not give promotion from that day. That is
The perspective.
that is the judgment.
Perspective.
Yes.
So
But that prospectiveness will go. Suppose you have given wrongfully a promotion to his junior from that day, ignoring his seniority. Then it will be retrospective from the date his junior is given. Next below rule. So these are the fundamental principles.
In this judgment, I have given my lord,
so
para 6, it is there, it's mentioned, my lord, para 6, the Supreme Court, 5 judgments have been referred there, that I have given what my lord. 5, 8 and 9 paragraph, please,
Which paragraph?
paragraph 6, my lord. In so far, the grounds on which the state responsible denied the petitioner from being considered.
That we understand, but we want to go to the judgment. If in these judgments ratios are not even stated, what are the ratio of these judgments properly?
My lord,
Sorry to state it.
the Supreme Court judgment has been quoted here,
Where is that quoted?
page number 6, para 6. All the Supreme Court cases there, and then discuss.
No,
Para 6, 6, 8, 9, 10, 6, 8. Related upon the effect code rendered in number of cases. He submits that the effect code has clearly laid down the law with regard to inapplicability of the amended rule for the post which fell vacant prior to amendment of the rule. In other words, he submits that the post which fell vacant prior to the amended rule would invariably be governed by the old rule and not by the new rule. The law enunciated by the Honorable Effect Court will hold the field as on the date, and therefore the amendment of the rules of 76, which came into force from 28/10/16, like this is it.
in
Yes.
our courtrooms, digital India is not properly functioning.
it's not getting information.
Hmm?
It's not getting information. So my submission is.
No, that's not that. This digital India is not properly working inside this. Yes, Union of India, what are you doing? Who is Union of India?
So far,
It will be a contempt.
our submission.
Breaks, it breaks the like
Like
thought process, my lord. Dispensation of justice.
in our stand is my lord. In Europe, nobody.
What is your stand? Let us
Our
see.
lordship, please see paragraph 7 our affidavit. my lord. As regards the statement paragraph 8 to the restriction
Mobile.
are matters of record and further that back to state that Director of Municipal Administration had advertised on 16/9/2014.
Which paragraph, Mr. Sutia?
7 our affidavit.
Just a minute.
Please separate it.
Hmm.
As you also quote it.
Hmm.
7.
Hmm.
middle portion. The deponent expressed that the Director of Municipal Administration had advertised on 16/9/2014 for filling up 6 number of posts of junior assistant, that is LTA, and number 1 computer post. But the examination could not be held due to non-approval of financial help from the government.
Okay.
That was not completed. And at paragraph 8, he says, my lord, the petitioner said that on the record, it was further, the deponent said that the petitioner had submitted an application on 27/1/2016 to then Director of Municipal Administration for promotion to the post of LDA.
Where is your statement regarding qualification and amendment
Yes,
of it?
I will come to
Mm.
it. Particularly 8 paragraph. The petitioner had submitted an application on 27 January 2016 to the Director of Municipal Administration for promotion to the post of LDA. But the petitioner has withdrawn his application. Follow his promotion, he withdrawn his willingness on 5/3/2016. As the petitioner has withdrawn his application on 5/3/2016, hence it was not necessary to collect information from SIP. I think he submitted his application for RTA. And paragraph lordship kindly see 10. Further, the deponent expressed that the petitioner has already withdrawn his application for promotion for the post of peon to the junior assistant. The Personnel Department, Government of Assam, has issued circular on 27 September 2016 that for appointment to the post of junior assistant, a candidate must possess a bachelor degree from a recognized university. The petitioner has passed SSLC higher secondary pass, hence his case was not. That is our stand ballot. He himself withdrew his proportional aspect. One person is slipping over his right ballot. Can we help it? Can he back for a submission before the Sonapul court that his right is violated?
Suppose I'm telling, a person is not even file an application for promotion.
The department has to initiate it.
So a filing of an application or withdrawing it is having no relevance so far relating to consideration of a promotion in terms of extended service rule. Until and unless the service rule provides that a person for promotion is to apply for promotion.
That is too much. So we have mentioned your paragraph 7. So we initiated it, Palo, to fill up this high promotion.
No, that is for direct recruitment.
That was
For direct recruitment, not for promotion.
posts in the office note says page 37. 2 posts for promotion. Can you see page 37 of my petition? 37 page. This office note. RTA through I have got. It post for private.
When your promotions were due, according to you, confirmed on 2013, is not it?
From the date of confirmation.
It will be
Yes.
should be from the date of confirmation.
Till 5 years.
5 years.
5 years. Because
So-
I am higher secondary. 5 years.
5 years.
18, it will be 18. 18.
18.
Now, my lord,
Where is that Mr. Tutia? That 27/9/2016. When you become eligible?
otherwise, as per what
Actually,
he
from the 1992.
No,
in
cannot
the
be.
appointment.
Cannot be.
It
Your
was calculated.
1992 premises are temporary. You just, there
Temporary.
is no selection, nothing. Somebody
like that.
picked you up and
In those days, remember, my lord?
anyway,
Those days.
but to,
Lord, you have done the-
days are changing. So when your right matured to be promoted,
My, this is, according to the petitioner, he counts from 92.
no, forget about the petitioner. At least from the date of confirmation, he is confirmed in a
13.
service on 13,
13.
14,
30
15,
years counted, they will be out.
you are out.
Counted, my lord. But with all those others who were promoted, my lord.
They were in
Along with him, I
83.
given the example.
No, they are 83.
No.
They were appointed, they promoted in the year 83.
Must continue to.
Mass senior to you.
From that
And
angle,
promotion was given.
No.
to my lord.
We'll have to take a legal view. We cannot take a view of a client. He might have said that is, I have entered, he's a casual worker, my
no
consider,
aspect of this, my lord.
Huh?
No,
no argument. That is the beauty of Mr. Nath. Hard. Mr. M. Nath, learned senior,
Chances are wasting time. I don't like it.
Mr. Nath, learned senior counsel, assisted by the
They protected.
A. Bhattasarji, learned counsel for the petitioner. Mr. T. Sutia, learned counsel. representing Lalit additional senior governor is representing the grievance of the petitioner is that petitioner is the right of the petitioner for consideration of the promotion to the next higher post of LDA/junior assistant has not been considered by his employer. Full stop. The petitioner was your appointment order
Page my
20.
page 17 initially. Page 17.
The petitioner was appointed a petitioner who was working as a peon against leave vacancy with effect from 2011-1991 under the Directorate of Municipal Administration, Assam, was by an order dated 8th of January 1992. Okay. The petitioner working as a peon against leave vacancy with effect from 2011-1991 in the Directorate of Municipal Administration, Assam, was allowed to continue as peon in the resulted vacancy. In the resulted in the vacancy of one Sunanda Kolita peon who was appointed as Muhurar, Muhurrar. Full stop. The petitioner continue in the such vacancy. Subsequently, his service was confirmed in the directorate by an order dated. Where is that? A confirmation
Page 33.
Was confirmed. Confirmed. While the petitioner was working in the aforesaid vacancy by an order dated 27th of March 2013, by an office order dated 27th of March 2013, issued under the signature of Director of Municipal Administration, Assam, Guwahati. The service of the petitioner, along with some others, were confirmed in the post of peon with immediate effect. That is, with effect from 27th of November 2013. The case of the petitioner is that in terms of Rule 10, Rule 10(3) of the Assam Ministerial District Establishment Service Rule 1967. 70.
Assam Directorate Establishment.
Okay. Sorry. Assam Directorate Establishment within bracket Ministerial Service Rule 1973. The petitioner is having a right for consideration of his case for promotion to the next higher grade of LDA plus junior assistant. Full stop. However, his case for promotion to the next higher grade has not been considered. Full stop. Rule 10 2 of the rules 1973 prescribes that the post of junior assistant should be filled out by two modes. Firstly, by direct recruitment, and secondly, by selection on the basis of suitability with due regard to seniority from amongst the class 3 employees as classified in the Assam Services within bracket revision of pay rules 1983. Uh, 83 whose scale of pay is less than that of a junior assistant. The other prescribed qualifications are that the incumbent should pass higher secondary school leaving certificate examination / pre-university examination or equivalent examination and must have rendered not less than 5 years service in service on the first day of the year which the selection is made. So far relating to other candidates who are matriculate or equivalent, the length of service is prescribed to be 7 years. Length of service is prescribed to be continuous service of 7 years on the first day of the year in which the selection is made. This is the rule, Mr.
Yes.
As on date.
Yes.
As on date, this is the rule. Full stop. This is full stop. When the writ petition was filed,
Amendment is made in 27 September.
27 September. What is the,
Our affidavit,
where is that amendment?
our affidavit,
Is
page pilot 87, annexes G. Before filing this petition, that amendment was
what is the
notification 27 September 2016. Rule 10 C has been amended. I will also quote it.
Hmm.
In our affidavit. Three, 10(3). By selection on the basis of suitability among grateful staff of the office who possess bachelor's degree from university recognized by the government. That is the amendment. Earlier it was a higher secondary.
However, however, such rule was amended, amended and notified by a notification dated 27th of September 2016, whereby the minimum qualification prescribed was
Bachelor.
was amended to be bachelor's degree from a recognized in Vishwa University from degree from a recognized university recognized by the government of Assam and
As laid down a rule 312. Have
that
rendered
will
processing-
that will go later on. Here is the proof.
Yes.
And not less than not less than 7 years of continuous service in the office on the first day of the year on which the selection is made. Full stop. Such selection was made. On the petitioner service, the service of the petitioner was confirmed on 27/11/2013. 13. And therefore, prior to the amendment of the rule on 27th of September 2016, the petitioner did not acquire the qualification to be considered for promotion under the old rules. Full stop. Under the old rules. The fact also remains that though petitioner has acquired the required length of service in terms of the new in terms of the amended rule, he is not qualified to be considered from promotion in terms of the amended rule. Full stop. As the petitioner did not acquire the required qualification in terms of the unamended rule, unamended rule when he claimed for the petitioner. At this stage, the petitioner, at this stage, the direction cannot be issued for consideration of his case for promotion in terms of the unamended rule, and at the same time, he is not eligible for consideration in terms of the amended rule. Full stop. In view of the aforesaid, no writ of mandamus can be issued even for consideration of promotion of the petitioner to the next higher grade. Accordingly, the writ petition stands dismissed being devoid of. That's all.
Great relief for him because this man my is near his house. He has made his life here.
That's all.
Now I can tell you one thing what happened. My last friend make a statement I could not. The reason is what my lord. I asked him, I told him, why did you do it? He said, the director told me, it is threatened me, if you do this one, otherwise I'll penalize. Out of fear, my lord, he said that.
Whatsoever, that is not relevant.
No,
Suppose
that's why.
a person is having a right for consideration. If they are not considering, he files a representation, withdraws this. Will that wipe
No.
out his statutory right? It will not.
Not at all. But that's why I didn't make a submission of that, my lord.
That's
What is happening?
and
Newly interested.
every day this is happening. Why? Huh? That's why this is happening. Every day, it's not one incident. Why you need time? This is item number
10 to 14. 14.
10 to
14. I bet. After this, keeping some.
Okay, let us proceed.
The courtship method, date method, item code 14, quick cover of the
Item number? Item number?
14.
Notices are served upon the respondent.
Yes, ma'am.
Paper publication in all the cases.
All the. My lord, WPC 3296. Wait. That the petitioner got yeah, initially measure 42 petitioner matter. During the pendency matter, 5 petitioner matter got selected. Regular basis matter.
Just a minute, just a minute. Why you need time?
Duty interpretation. Okay.
We cannot help it. This is a 2018 matter. What is the advertisement?
Advertisement on page 83. Page 86. C. Post of ANM. T. Roman 1. 35. Number of post. My initially qualification was higher entry. And my lord, general instruction below it.
Post of A&M.
N. Yes. And below my lord, the process walk-in interview for regular matter. But
Did you walk in?
walk-in interview.
No. Did you walk into?
There was nothing done by lord.
No, no. We'll go.
Yes.
There was a walk in. Did you go there?
Yes.
You go there.
Method higher secondary qualification subsequent method deduction class 10 method page 7. Because earlier we tell it because method earlier method qualification was metric. And 2017 method qualification for higher secondary. So they themselves method relax method is method the merit list or select list whatever can be called method page 88. Method 35 post advertise method.
What was the date of the advertisement?
Is the date 22nd November 2017. From
And
paper
what was the date of walking interview?
uh,
7,
December.
Okay, then
Same method it's a list method page 88. It is method just roll number noted and 56 against method 35 post advertise method 56 candidate declare method qualified. It is not a merit list. Just roll number. Yeah. And thereafter method 56 appointment made method. Although method 35 post was advertised. Appointment letter subsequent to repeat.
what is your ground for select?
ground floor matter, separate terms are there.
We'll come back, we'll come back.
What is the held on 7 and 8th of December.
See, three questions here,
Right.
Mr. Sohan. The advertisement clarifies that it will be walk-in.
Yes.
You walk into. Now we'll have to answer whether that ground can be taken by you that this is only walk-in without challenging that walk-in. Your second argument is that there were post advertised were 35, appointment mates were 56. The advertisement was issued on 22nd of November, where it was specifically stated that the number of vacancy of post may likely to increase or decrease subject to approval of the BPT authority. So there was an anticipation in the advertisement itself that can increase. Whether that can be a ground for setting aside selection of other persons. Number two. Number three, you say that there was reduction on all educational qualification.
They themselves matter, no question.
Huh?
They themselves matter.
They reduce. Advertisement was on 22nd of November. Date of interview was 7 and 8 December. And it was notified prior to the selection on 2nd of December. Okay. So those person, somebody might have come and say, see, you have given only 2 days. We are matriculate. They are not before us. Those who could have been aggrieved by reduction are not before us. And you had a notice of that on 22nd December, despite that you have entered into you participated in the selection. Therefore, in that context, what are your other grounds of challenge to the selection? Now you are happy.
Why
You do not need time. Is that it? Take your seat.
matter?
Take your seat.
My first ground matter, although matter there is matter. Matter mentioned that post may be in. Still matter is the HR matter advertisement at time.
Yes, 35, but it's not.
Matter
We know the law that it should be generally the advertised post should be filled up, not beyond that.
Right.
This is the law. But the reason of such ratio is that so that the other persons who were not qualified on that day or somebody may those vacancies which are subsequently arises should be advertised subsequently. But here case is not that. Here case is that calculations are going on. This is the tentative vacancy. It may increase or decrease also. So we do not find any illegality to interfere with the selection.
but matter 21 person matter in excess. Matter selected and appointed.
Not in excess. They say that there may be increase.
But the specific number is there.
That cannot be a ground for setting aside a selection process.
That matter is Supreme Court says that matter.
Hmm.
The matter is excess appointment.
Article 14. Why Article 14 violation?
Because other
Because other peoples are not getting the chance. But here that is not the case. Here it says we are making calculation. Now it's 35. But after calculation, it may decrease or increase also. So there is no question of subsequent vacancy. They says we are calculating. It may be 35 or it may be reduced also. You are well aware of that.
my lord, initially my lord, we this my lord challenge the selection process because my lord work in interview. They're not at all my lord. They're not at all my lord. Supported by a rule and not it is my.
No, not supported by rule. Which rule?
Any rule, my lord. If they can show that,
No, no, you will have to show that this is barred. That this is the service rule. Service rule prescribes written examination and this, and there is no prescription for only interview. Show us that.
my lord, quality, picture, 12 page 98.
Huh?
Page 98, picture,
And we will take page.
page 98, picture 2.
Page, there is no page 98. Which read petition?
My lord,
3296.
3 to 9.
3296.
And picture 2.
Page, page.
Page 98, picture 2.
Okay, 98. Okay.
My lord, this is my lord, office memorandum, my lord, issued by my lord, the principal secretary of the government of Assam, WDP and department, my lord. It was, my lord, issued pursuant, my lord, 4 to 10 accord, my lord, between the government of India, the government of Assam, and my lord, is a PLT.
So this rule says you appoint as per rules. Show us the rule of appointment of ANM.
Well, can you see this Roman, sorry, my next page, 8. F8. 8 says, my lord, PTC shall be competent to make appointment on all posts under its control in accordance with the rules of appointment followed prescribed by the government of Assam. The council shall continue a selection board for constitute a selection board for appointment made by it and shall make rules with the approval of government of Assam to regulate appointment.
I have read this. My reading is complete. So according to this, now tell us which is that rule
My lord,
for appointment of ANM.
PTC has not framed any.
So if they have not framed any rule, what is the state government rule for ANM? Tell us.
My lord, in all posts there must be a selection, my lord.
There is a selection. They decided to be walk-in interview.
My submission is not selection, my lord. What interview is selection?
But we have participated. We have not challenged it.
not a challenge. We challenge that.
Where is that?
Here.
What happened to the challenge?
My lord,
Huh?
It's a attempt, but
Prior to participating in the selection, you have challenged it.
Yes.
Where is that? That is your vital guess. Which one?
and the attempt, but
Tell us the number of the
1713.
17.
1713. Where my page 21. Sorry, participant.
Election was notified.
But my lord, no written examination, no oral interview, no any merit is even prepared, and no matter reservation policy followed, lacking the paper. Only my lord, the good number second, my lord, my education also for extraneous data of the department, my lord. With respect, my lord, I am relying, my lord, judgment or not. Right. State appeal, 337. Pankaj India, my lord, paragraph 21 and 22.
Which paragraph?
Paragraph 21 and 20. That is the way that for the common implement, the authority that taken up is the only criteria. That is the- in our conservative exception, that is permitted in the matter.
Paragraph 21.
21, yes, 21 expected for that. So, always certificate are there. It might not have that. If you find out there is no even a forest cut.
Okay, then which then other judgment?
2009 March 8, the case from Assam matter to the
Yes, please.
paragraph 164.
Paragraph
Paragraph
54.
44.
Okay, then
1998, my
1998. Kushal Kishore.
yes, Bihar, paragraph 4 and 5.
Paragraph
4 and 5. Put to place any merit.
Yes,
Because if there is no rule matter, they should have adopted general norm and procedure for selecting candidates because such a regular, matter. And without matter preparing matter,
where
there
have they filed affidavit?
no affidavit filed.
Where is the selection record? Cost 10,000. Art. Mr. S. Soha, learned counsel for the petitioner, and R.K. Mustahari, learned counsel for the. The petitioners are diploma holders in auxiliary nurse cum midwife, within bracket, and ANM. The petitioners claims to be diploma holders in auxiliary nurse cum midwife and claims to be serving as nurses on contractual basis under the National Rural Health Mission in the Bodoland Territorial Council BTC jurisdiction. Full stop. An advertisement was issued on 22/11/2017 for filling up of 36 35 numbers of regular vacancy of ANM, and a date was fixed for walk-in interview.
7 and 8 people.
Walk-in interview on 7 and 8 December. 7 and 8 December. The petitioners participated in the said selection process. However, they were unsuccessful. Full stop. In the aforesaid backdrop, two sets of writ petitions are filed. Firstly, in WPC 1713/2018, the petitioners claims that they ought to have been given weightage. They ought to have been given weightage for their experience. The second batch of writ petition is filed assailing the entire selection process, primarily on the following ground. Firstly, that the selection ought not to have been based only on oral interview. Secondly, the notified vacancies were only 35. However, persons appointed were 56 in numbers. And thirdly, no merit list was prepared or published before appointment of the private respondents. Full stop. Though this matter is pending since 2018 and appointment of private respondents are made subject to the result of this present writ proceeding. However, the BTC authority has neither filed any affidavit in opposition nor the learned counsel is in position of the selection record for proper adjudication and determination of this case. Proper adjudication and determination of this case. And after hearing at some length, after hearing the learned counsel for the petitioner some length, the learned that the standing counsel for BTC has sought for some accommodation to produce the selection. Full stop. Such prayer of adjournment is granted considering that for proper adjudication, the selection record shall be required to be perused in as much as a specific allegation has been made that no selection list was prepared, no selection list on merit was prepared, and appointments were made on the basis of on pick and choose basis. Full stop. Accordingly, such prayer for adjournment is allowed, and it is directed that the learned standing counsel for BTC shall produce the select list in question on the next date fixed. Full stop. On the next date fixed. Let this matter be listed on February 23rd of February 2024. Full stop. If the authority / respondents, state respondents desire to file any affidavit, same may be filed on or before 21st of February 2024. If a record is not produced on such date, the respondent number
The respondent number 3, director.
Respondent number 3 shall deposit an amount of rupees 10,000 as cost. Release this matter on 23rd. Mr. Sohan, be ready. What is the selection rule? This is your vague statement will not do.
My lord,
And you have participated in the selection. You have to satisfy that.
By my lord, my senior principal, my lord, but he
This court do not require any seniority.
I
We'll require senior when we are confused somewhere. এটা আমার কাছে আর সব মাথায় অ্যাপ্লাই করে স্টেশন দিতে পারে হঠাৎ করলে বলবে এখানে আমার খবর পেলাম করলে মানে আমি
we have filed the affidavit as petitioner is paying for pension. Disposal of the DP. He has to dispose of. That's the criminal case.
Where is your affidavit?
affidavit filed by respondent number 3.
When?
How this date is not showing in the fact.
You have not filed it.
It is,
You have not filed it.
otherwise it is ready.
Hmm.
You-
What is your stand? Give us the copy. You have not filed it. That's why there is no date here.
At paragraph number 9. Internal page number 2.
So none appears for the petitioner on call. The petitioner was an UP constable. Was initially appointed as UP constable in Assam Police. Assam Police, and was subsequently promoted to the rank of ASI within bracket UP. While serving as ASI UP at Mahur Police Station, Dima Hasao, a departmental proceeding was drawn against him in the year 2010 on allegation of misappropriation on allegation of misappropriation of some money which was seized in connection with Mahur PS case number 8 of 2009. During the pendency of the departmental proceeding, the petitioner retired from his service on 31/12/2013 on attaining age of superannuation. The grievance of the petitioner is that petitioner has not been paid any pensionary benefits, and there is proceeding, and the departmental proceeding has also not been concluded. Full stop. This court, accordingly, the present writ petition was filed. This court, under its order dated 27/7/2018, as an interim measure, directed the respondents to forthwith pay the provisional pension to the petitioner. However, till date, no affidavit has been filed by the respondent authorities, nor Mr. D. Bora, Learned Counsel, is aware whether the order dated 27/7/2018 has been complied with.
Not for that, your lordship. Otherwise, I'll file it. Just lordship.
What will you say?
Here we have stated with regard
What
to
you have
the-
stated, tell us. You
So
said we received the order. Have you stated that you have
Yes.
paid it?
Yes, yes, the paragraph number 11, your lordship.
Yes, read it.
The proceeding for release of provisional pension to Sri Vinod Kumar has been initiated and communicated by letter dated provisional pension dated 31/8/2018.
Huh.
The matter was listed
So
on-
therefore, can you say right now that pension paid?
Let me seek instructions on that.
That's why I'm saying can you say?
Right
So
now.
that's why you have recorded. He's not in a position. No affidavit has been filed. And Mr. D. Bora, Learned Counsel representing the police department, is also without instruction whether the order dated 27/7/2018 has been complied with. Though he has submitted that process for compliance was initiated way back in the year 2018 after receipt of the copy. Full stop. That being the position, list this matter on Friday, next Monday, Tuesday. 20.
I'll be on leave, it's Friday. 16th,
Friday is today is the Friday.
next Friday, 16th of,
Okay, list this matter on 16th of so and so, so and so.
otherwise, your lordship, the charge sheet has been filed. In page number 21 of the report
Charge sheet file, charge sheet of what?
of the
Whatever
criminal
you say,
case.
where criminal case or departmental proceeding.
Department proceeding has been disposed of.
What is the finality?
2 black marks were
Okay, okay, 2 black marks were imposed. That is fine. Whether you can withdraw pension on 2 black marks. Number one, if criminal proceeding is pending, now you are bound to pay provisional
Provisional.
pension.
I think he has been paid because this matter was last registered on 2018.
No, we understand, but we cannot give. Petitioner is not present. We can dismiss it for default right now. But it relates to pension. We
Yes,
cannot do that.
I just found out the latest case
16th.
status in the.
Whether that is, you come with a order of provisional pension and close it,
Yes.
subject to his right to agitate against any action taken. Okay. 6, on which date the petitioner, the learned counsel shall apprise this court regarding compliance of this court order dated 27/7/2008. Because it is you to pay. It's no
Yes.
question of AG also.
Yes, yes.
Yes, Mr. Sahaywala. Just, we have committed a mistake yesterday. You understand? Because nowadays, we cannot directly name a person. Isn't it? We'll have to determine that so and so will be the arbitrator. Then we'll ask the registry to have the consent. Then only. Otherwise, suppose we say that is none.
My lord,
So,
consent is required.
what was the amount total claim?
If I'm not wrong, my lord, somewhere around
What will be the fees as per schedule?
20 to 50 lakhs
Okay, 18 to
divided between both the parties.
anyway, but because nowadays what happen is that arbitrator cannot fix its own
Right.
So sometimes many arbitrator may think that it claim is very less, why should I? So if it is returned, then it will be difficult.
My lord, may direct to the registry to
So therefore, we have not said it to be disposed of. We have made the determination, pass an order to that effect. We proposed
justice sir. Retired judge of
SK, we thought of my Lord Justice A.K. Goswami.
Right. No.
No problem.
no,
I do not think he has no difficulty taking.
it's something there will be recused from him just
But
because of
it's,
being
but
the
huh?
he being the
That's why.
Yeah.
So you have a talk with your dad and just get
My-
out. Otherwise,
my lord, I'll appraise your lord
Huh?
by one.
on 115. That
My-
is the anxiety.
My lord,
But
my lord,
otherwise, earlier they used to do cases.
My
It's not a problem.
I'll appraise your lord.
Just you have
Yes,
well, you can give the information tomorrow
Yeah.
also. We want that this has been
Yeah,
accepted.
115, my lord.
Not 115. You have talk and your dad will tell it tomorrow.
Right.
I'll not tell more than that.
My
Okay.
Keep your. Praise the Lord. Lord, I want to have a Mr. Jan.
Hmm.
He is not, it is not Lord. It may be accurate.
Affidavit file. A prayer for adjournment is made on behalf of Mr. D. and Bhattacharya, Learned Council, who is stated to be not keeping well. Full stop. Prayer of adjournment stands allowed. Please this matter after 4 weeks on a
Okay.
date to be fixed by registry. The Learned State Council may keep the record of the department proceeding ready for perusal of this court on the next day. Yes,
Yeah.
yes.
About but not bad.
Mm.
But we are the big operas.
There are some, it has been covered.
Lordship,
There are some reasons as well.
Lordship, my lord, that procedure can it be taken at 2 p.m. My lord, I will mention
It is
that.
covered. Pending.
Already, my lord, that Dhubri district court was
Uh-huh.
directed to my lord that go for the selection process. My lord,
There is, I have seen somebody
Lordship,
relied on.
Lordship.
Okay,
The
at two.
corona deka, my lord, at 2 lord. I will bring it.
We'll see at two. Sometimes you need to remove the ventilator.
I'm not
It
able-
gives you the time to devote to other patterns.
That-
Isn't it? And that also gives up time to concentrate on more desirous cases.
So many cases has been disposed of.
None appears for the petitioner at all. Accordingly, the petitions are dismissed for non-possession.
ARE lordship for promotion and appreciating. This is so. It could probably become infraction. His age is the prayer person.
Yes.
His age prayer portion of the petition. Since 2018, the suit is first after notice being issued, its second operating matter has been listed.
None appears for the petitioner and call. However, in the interest of justice, matters can adjourn and be listed. Up listed on given date. We'll see.
Lord,
Kenji says that my juniors are appointed. I have not been appointed.
no more.
There may be some further. Given date. 1st of March.
Public.
So, Mr. In the meantime, the learned sending council for the irrigation department may obtain instruction.
Public.
This is for termination of service matter.
Ah,
Termination of service matter.
why terminated?
Because earlier Krishna was appointed as a Chowkidar Mail.
Hmm.
In 1991, my lord, he was appointed as a meter reader. And therefore, what happened after some time, there is allegation that the certificate has been produced
Hmm.
has been found fake. Therefore, he has been suspended and disciplinary proceeding was started. And he has not appeared before the disciplinary proceeding, and disciplinary proceeding was past expiry for the terminated. In the meantime, my lord, the committee on the same for the action matter, criminal proceeding also going on, and Honorable High Court, my lord, has passed his judgment and order dated rather 8/1/8/2013. Exonerate the
Where is the departmental proceeding? Departmental proceeding.
yeah, he has not appeared.
What is the decision?
This is on my lord. That is the page 51, my lord.
Huh?
Page 51.
What remain?
But I have found to tell Metro the honor.
What are these judgment?
Thousand six five Supreme Court 4465. Para 20 at
Paragraph?
20 2006 5
Paragraph 20?
20. Yeah.
These are not a judgment. These are running simultaneously parallel. In your case, you have already been
Let's 30 plus.
Huh?
Let's 30 man.
Tera?
30.
Where is your search memo? Departmental proceeding.
Page 30.
Hmm?
Page 30.
1,
Page 30.
30.
38.
Where is the FIR?
FIR is
Huh?
higher.
Then how can you determine it? Where is the search sheet? That is also you have not annexed. Search sheet.
I my lord, connector 50.
Huh?
Yeah, sorry, page 50.
It's a statement of allegation.
No, my lord, it my page
Yes.
50.
50 is the
Yes, ma'am.
statement of allegation.
The Dhiren Chandra Mitari are under suspension. Songaika will division 2.
You are recruiting Assam, as you,
That's not 50, my lord. 50. You see
50.
Dhiren Chandra Mitari that
50 starts with something different. Go to your index. You have not even made a mention. Go to your index. Where is your FIR? Page 48 to 50 is the copy of the said search sheet dated 29/3 to 1994. And page 50 starts with page index is a page 50
Oh, 50
48 50.
yes, my lord, that's it.
Search sheet, but here is you
Yes,
come
my
to
lord, that's
page 49 annexure 2 list of documents. Page 50 annexure 1 details of statement of allegation. Page 51 is the order of punishment. Then page 59 judgment.
it. Copy of the charge sheet data set. And actually, I page 50 there. What's the problem? May I copy of that?
Yes, Sharma.
The charge of both is the same here.
Case 75, paragraph 17.
However, my lord, on the last occasion there was a delay in this the defense. Which
When he was writ petition was filed,
It is
2018.
when acquittal,
Acquittal 2013.
13.
acquittal 2013, and writ petition filed.
2018.
Don't give any benefit for this, let's say. Think over it. We are not deciding it. But law is clear.
Yes, yes, no.
Law is
Right.
clear.
What has fallen from my lord, even I was going to the same but
Basic fundamental thing is whether charge is same and evidence are same. Their charges, only charges had it with some other that certificate. Now it is established, it was a case by the appellate revisional court that there is no evidence.
there's no evidence.
468 not at all proof that he is the author of the manufacture. So it's coming to the 420. It says that when 468 is not proved, 420 will
Not
not.
Yeah.
And other aspect of the matter is that there is no evidence at all because
Yes.
the documents produced were Xerox copy of some documents which are not relevant. That is one aspect.
no, he may be directed to produce the FIR and the till then I may also take an instruction.
There are some judgments, more judgments. If you can have a
So,
your thing is go through the record. If necessary, bring on record. We are not passing any order. Make a statement that there is a mistake in an excerpt, so we will brought in it. Will at this stage a 2018 method will not allow amendment. See, go through it, page 50, where is it? If at least it is there, I could not found that is a difference.
And page 37 also.
There are some recent judgment 2020.
with regard
Court.
2024. I got that.
Supremacy is at page 37, allow that it was there.
Page
37.
This is by the
Oh,
not this charge. This is by the police.
No, I'm not saying. I'm not an expert.
that is the input. Anyway, judgment is already there. Charges are there. FIR content is
Yes.
there.
My lord, fixed it in
Sometimes it's better not to file an F. Isn't it? Who will determine that this is a case of honorable activity? The judgment he is relied on suggests that it should go to the employer. Then,
who will decide this or
huh?
the MD.
That will be sitting over. Anyway, we'll think about it.
My lord,
Day before yesterday, I think HR Khan. Which date? Item number 1. D. Mozumdar, D. Das. Nothing. Who's that?
well, I'll do it to live stream. I'll get it.
We have not uploaded because we'll do a fine tune in the judgment.
Yes, sir.
Here also we have direct for reinstatement, but in that case, departmental proceeding was pending, so we allowed to continue because there are additional charges were there. But that is not yet uploaded. Do you want to write the proper judgment?
I'll just go through the stream.
Here we relied on certain judgments. Those may help you, but should be the on the prayer of Mr. S.P. Sharma, Learned Counsel, matter stands adjourned. It will be listed on
As my lord.
No, you. Our
The
board is full on up to February, 4th of March. Think about it. Imana sir. Okay.
Look, for the review,
Hmm.
for the
Where is the order?
logical come to it starts at page 18.
Page 18.
Page 18. Order dated 17 plus 2016.
Hmm.
Plus, there also you will find the page 17 for Northmoni Hazarika and Deputy Tule. They
Page 17.
page 7 Northmoni
Okay.
Hazarika and Deputy Tule, they are the petitioner teacher.
Okay.
The Northmoni Hazarika, she has applied for Anganwadi helper, and Deputy Tule, she has applied for Anganwadi work. And the Respondent number 6 and 7, they are occupying that particular post. I think the order starts at page 19.
Hmm.
It is from Dharan. An advertisement was issued from the office to CTPO dated 16th and 2019 inviting applicants among others from for the various posts of worker and property helper under the inspected ICT work purpose thereof the selection and petitioner therein, namely non-necessary deputy for appointment of property worker and property helper by two orders, both dated 11/3/2013 as by the office CTPO work without carrying the petitioner as content. The reference was 6 and 7 along with one. There was a preferred topic. The state literature was given a final consideration by the order dated 27/6/2013, which is expected Canada. So I think comes to this, the order is put it on 6/5/2000. This court directed the Lada Standing Court to obtain the instruction as to why the petition have not appointed the Authority Court card, despite the expert report 29/1/2007 on 6/6 time of call for by the Lada Standing Court to obtain necessary instruction. Today, the matter is called for. The Lada Standing Court submits that he has not post the requisite from such circumstances that the court is of the view that the case is to be did not kept pending and necessary direction may now be issued to respond number 4 to issue necessary constitutional engagement orders of the petitioner as Anganwadi worker in their respective Anganwadi centers. Such engagement or orders shall be issued within a period of 1 month from today. It is discernible from the order dated 27/6/2013 that firstly the state order was passed for the respondents the social welfare department have failed to provide necessary information to the court as to why the petitioners were not appointed. Accordingly, the direction was issued to the CTPO to
Which you are seeking review of which order?
of these.
You ought to have sought review of the earlier order.
But the earlier order has been applied. The earlier order nothing.
Your case is that two persons were already appointed. So you have directed us to appoint this person. So we don't have any option but to terminate them. But earlier order, they were not parties. They were not parties. Whether they are meritorious, others are meritorious, not determined. There was a direction for engagement. Seek a review of that order.
In fact, I think this 26 years, their doctor directed that they should be appointed after the inspection in 2003.
You should seek a review of this order because there cannot be subject to correction. There cannot be a direction. You can seek a review that there are already persons appointed. They were not made respondents. Where they made respondents? They were not even made respondents.
No, in this case, they were not.
These two persons whose termination you have order of termination you have issued were not
Made party.
quit parties in the respondent.
Look.
There was no direction for terminating their service.
Yes.
So therefore, you have no option even but by creating supernumerary post to appoint them.
So we cannot.
You cannot.
We cannot.
So since you cannot, your bounden duty is to seek a review of that earlier judgment.
But-
What happened to these two persons? They have not come for review.
But no, they have. In fact, now, because now they have filed a petition.
WBC 2334.
2334.
Uh,
2334 is filed by
these
File by-
petitioners
Debojani Gogoi for these persons
who are sought to be removed.
who are
What is their case?
ASF.
Where is there any order passed in the petition?
It is upholding.
What is the disposal order?
Plus, this is it. In the meantime,
Where is the pace? Which pace? Those persons whose uh, 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 election are sought to be, who are sought to be removed, they have preferred a repetition.
kindly, I'll take it. Kindly skip the page 20.
Pace 25.
Page 20. Page 25 is the order. After the signature order, in person, the director of Assam, order number 20 for the respect of Honorable Court ordered, then 2324 of 2013.
Okay, you have cancelled. We understand. Your anxiety is that we have already appointed 2 persons. We have been asked to appoint 2 more persons. So we have no option but to terminate. But that was not given. That termination, you cannot take away their right on the basis of right determined of some others without interference of their right. Okay. So this was the order passed where you are reviewing, so review is sought for. Now what happened to those persons? This the order is challenged or what?
This order is kept.
And what happened to that?
And now that after challenging this termination order has been set. Termination order is set aside. Kindly keep the page
Page 20.
page 2. I'm just concluding part of para 5. For the reasons stated above, we set aside the 2 orders of cancellation in 2016 of the CPO by which the appointment of the petitioners were. These are the petitioners that they were removed because of the Honorable Court order. Ultimately, there was no the other person. These have been cancelled as we have already arrived at a conclusion that no reason was discernible for effecting such cancellation. The reasons to those stated are unknown.
Seek a review of the earlier. We are issuing a notice here.
Now,
Who is working now?
now the a writ petition has been filed by them again.
Now other party.
Other party they are the respondent.
Now what is the order passed in their case?
It is pending for whom? It's not for
What any order passed?
WPC number 314 of 2021. That is pending for
4/1/2023. Order passed in 4/1/2023. Debojani Gogoi.
Debojani Gogoi is not connected with this, but he was the third petitioner. Debojani Gogoi was the third petitioner in the 2015 order. And it is
No, now see, let first order says engage these 2 partners.
there were 3 persons.
3 persons.
In fact, 3 persons.
The first order.
First.
First order. It says 2 or 3 engage this person, and the reason is that there is no instruction. Okay. No right of individual persons are determined, including of the petitioner, whether they are duly selected, whether they stand in the merit. Even it was not brought to the court's notice that already 2 persons are appointed. Okay. So on the basis of the said order, what you do is those persons who are not party to the writ proceeding, who are duly selected, you ask for termination of their service.
They were
That is challenged by those terminated persons where their termination is set aside. Fine. Now you have a difficulty of 4 persons against 2 persons. Isn't it?
Yeah.
So you want a review.
Yeah.
Now, prima facie, this court is of the view that subsequent order, it's not a case for review, but the original order is a case for. File a review. We are issuing a notice here.
Okay.
We'll settle all the disputes.
I'll
Okay, heard Mr. Dina, Learned Counsel for the Prisoner, decision review seeking so and so. Issue notice returnable on give a date. Steps within 10 days. Okay.
Okay.
Let us see.
Okay.
I think otherwise you have no way out.
these 2 petitions where, but opposite. They have filed the
But so give us the number.
lordship. I have stated it.
Okay. Okay, do one thing, make a mention on the next date after return of notice that this review is, this petition is pending. We will decide. If necessary, we'll reopen.
Page 40, paragraph.
So we are not passing that order today. You just remind.
I'll,
Step.
I'll,
All mess because of the disposal of the instructions.
Without-
That is that practice we have given up.
Lord, I run for the order. Another order passed by 649
Hmm.
that there is a direct government on for regularization without participation. There is order participation.
They are appointing by the public, my lord. How can their service to be regular as well as that?
Lord, that has.
That is, my lord, that as per my knowledge, my lord, that it is, my lord, that I did not find any, my lord, that order.
You want to keep it in ventilation for 2 more days?
My lord, on Tuesday, my lord. I will
Okay, on Tuesday.
Yes. Both
On-
orders-
Let them produce them, my lord, that.
That-
Yes, yes, yes.
Okay,
Lord,
on-
even after.
on
even the
Tuesday,
My lord,
forget about this judgment. We'll decide this matter on Tuesday.
And not even no adjournment has been given.
My lord, with all respect to my respected senior senator, I did not submit before my lord unfair because there is an order passed by the.
Okay, you take it.
My lord.
You take it.
Okay.
Okay. As agreed to by the learned council for the parties, list this matter on Tuesday.
Lordship, my lord, and endeavor to be material dispose of no adjournment.
That endeavor is always there. That's why you are sitting here. What do you say, Mr. Sutia? Mr. Sutia is having headache.
Lordship,
Go home. You have done your job. If you are not keeping well, we'll adjourn it. No, don't manage. No. Okay, next case. Your time being ready. Okay, Nayak. Yes, Nayak.
in fact, Lordship, the Paraguay's comments was furnished to the standing council in the year 2017. No exhibit has been filed. And subsequently, this matter was tagged along with another 2 matters.
Okay,
Those 2 matters got disposed of now. Pending, this matter remains.
this is covered by those 2 judgments.
No.
No.
In those 2 matters, those candidates were belonging to reserve category.
Okay,
Here he is a general category.
so do you
candidate.
propose to file an affidavit? Short
Lordship,
affidavit?
Lordship dispose it of also. Lordship may kindly see the last 2 pages.
Last
2 pages.
of the writ petition?
No, this one. Okay.
Your instruction.
Lordship, with a letter dated 19 June 2017 to the standing council. Lordship, petitioner's roll number was is 113368.
Okay,
In the next page, Lordship will see the number he scored, Lordship.
180.
He scored 180.
Ah.
Whereas, Lordship, the last general category candidate scored 215. So that is why this matter was separated from the other.
Ali,
Earlier, my lord, it was brought to the notice of the honorable court, my lord, that 11 posts are still lying.
no,
Lordship,
still,
that
maybe still
instru-
line.
That instruction is also here, Lordship. All those posts are reserved for reserve
And there is
category.
no waiting list, my lord.
Yes, Lordship.
But
of-
in a selection, you got 180, others got 215. Who knows that this election, others are in between 214 to 1
And
or 214 to
Post-
181.
post advertised 63.
Ah.
Appointment made, my lord, 51.
Hmm.
No additional list, no waiting list. Nothing.
No, it is clear from the Paraguay comments, Lordship, in the second page, Lordship.
And final
want
selection list
to-
was also paid,
Was also,
also prepared for a 51.
Yes, Lordship, because
And there is no, my lord, any
you want
kind of
also some ventilation.
why those posts
Where is it?
Second, Lordship may kindly see paragraph, page 2, Lordship, para 10, reply to para 10. Lordship, for as many as 12 reserved category posts, Lordship, no suitable candidates were available. All these 12 posts were reserved for general.
STP 7, STH 2, OBC, general was filled up. There is no vacancy for general. According to you, how many posts were not filled up?
12.
12, they have given a reply. Close it.
Close.
Heard. Mr. R. Ali, learned counsel for the petitioner. Also heard Mr. P. Nayak, learned standing counsel
Finance.
for the Department of Finance, appearing on behalf of the respondents. An advertisement was issued on 29/5/2015 by the respondent number 2, that is the Director of Audit within bracket Local Fund, Assam, for filling up of 63 posts of Assistant Audit Officer. Out of the aforesaid 63 posts, 11 posts were for STP, 5 posts were STH, 13 posts were for OBC, and 32 posts for general candidates. Full stop. The petitioner belongs to general category candidates. Full stop. It is the grievance of the referring to Annexure 9, annex to the writ petition. Mr. Ali submits that the aforesaid is a provisional select list published wherein only the roll numbers of provisionally selected candidates are indicated without any reference to the category to which the roll number relates to. And the select list contains only 51 roll numbers, though the advertisement was for filling up of 63 candidates. Accordingly, with the aforesaid grievance, the present writ petition is filed. Full stop. Mr. P. Nayak, pursuant to this court's order dated 31/5/2017 and 5/2/2024, has produced certain documents signed by the Director of Audit Local Fund, which goes to show that document. One of such document is statement showing the total marks obtained by all the candidates belonging to the unreserved category within bracket unreserved category, comma STP, STH, OBC, MOBC is shown. From the aforesaid record, it is seen that the last selected candidate belonging to the general category candidate obtained 215 marks within bracket written test 197, Viva was 18, and the petitioner obtained 180 marks within bracket written test 166, Viva was 14, total 180. And accordingly, it is contended that petitioner could not have, petitioner was not selected for appointment. Coming to the next grievance of the petitioner, that though total number of posts were advertised, total 63 numbers of posts were advertised. However, only 53 posts were advertised, 53 posts were filled up. Mr. Nayak, learned counsel, on the basis of his instruction and record, has submitted that uh, 12 posts were not filled up for one of qualified candidates, and those 12 vacancies were not meant for general category candidates, and all the vacancies of general categories has been filled up. Out of the aforesaid 17 vacancies, 7 numbers belongs to STP candidates, 2 numbers for STH candidates, 2 numbers for OBC/MOBC candidates, and 1 number for PWD candidates. PWD candidates. In view of the aforesaid record, which is also shown to Mr. R. Ali, Mr. Ali submits that the record, he cannot argue beyond the record, and record shows the facts itself. Mr. Ali, in view of the aforesaid contention and the submissions made by Mr. Nayak, learned counsel, as well as considering the statement produced and signed by Director of Audit, and this court of the view that this court cannot find fault in non-selecting the petitioner in the selection process. Accordingly, this petition is dismissed. The documents produced are kept on record and marked as document text. Mr. Nayak, this could have been decided long back.
2017.
2010. People are hoping Mr. Ali will give a good news. Isn't it? He will become an audit officer.
No, not the petitioner, he has a good academic record, but must have been a competent. But if instead of 53, it is 51.
51.
Obliged.
But what to do? Examination, he has not done well in the written exam. I think Mr. Ali, I think he has got some job. There is no connection with him.
Oh, today I have taken inspection, he is anything contacted.
I think that is it.
Teacher,
Yes.
but, my senior with the
My lord, this matter can be disposed of because my lord, a similar matter has been disposed in the same writ. This is about the selection process of 2018. My lord owns water. Question of delaying our experience of Sahayaka.
You keep it. Mr. Bhagawati is having some
My lord.
personal difficulty. So on his family front, his wife is not keeping well. So adjournment is short. We'll keeping this order. You go through it. Are you aware? This is WPC 1460/2020. Write it down. Mr. S.P. Sharma, learned counsel for the petitioner, submits that the present keep a extra copy. Many matters are coming with it. S.P. Sharma, learned counsel representing the respondent, submits that the similar matter has already been decided by this court in WPC 1460/2020, and the determination made in the aforesaid writ petition shall also cover the present writ petition. MS G. Bora, learned counsel for the petitioner, submits that she may be allowed to go through the judgment passed in WPC 1460/2020 and response to such arguments. Accordingly, matter stands adjourned and be listed on. Have an instruction from Mr. Bhagawati. Show it. If he says not, he will argue and there he want to distinguish. Then we'll adjourn on next day. If he says okay, it will be covered, it will be covered. Okay. List this matter. No, not 30. Before that. See, difficulties 2020 meters. We are 2024. We'll end. Huh?
Sir, can we have 29th?
29th of February. Okay. 29th. We'll definitely accommodate. Is having a problem. No issue on that.
I was not aware.
keep a Xerox copy and match. Or I'll be happy. 20.
May I please, Your Lordship?
Here, record, Ali Thambi, the record speaks for itself. Huh? Yes,
By the release of the area salaries and for the revival of the Kamul. Kamul means like a Kachar and Karimganj Milk Union Limited. Where the government of Assam has decided to develop the dairy development project lot in the year 1987. During this year, Kamul is the property under the government, served by the government of Assam to formulate and implement the dairy development project. And when it was established, initially the staff was thrown on deputation basis from the veterinary, agriculture, and cooperation department to government of Assam. And assistant dairy development officer of the veterinary department of the government of Assam was appointed as ex-office secretary of the government. So everything is going on, Lordship, and they are also getting the salary still up to 1994. In the month of December 1994, when they are not getting the salary, Lordship, they approach, they filed representation before the authorities, Lordship. But they have not, when they have not replied, they are deprived from the authorities, Lordship. They filed a civil appeal, civil rule before this Honorable Court by 2996 of 1995. This Honorable Court has also gave direction to give their salary, Lordship.
now what kind of order can we pass? Except imposing a cost upon you for coming once time and again.
Yes, Lordship.
Huh?
I'm just to kindly come to another 5 Lordship.
I will shorten the matter. You are a union,
Union.
milk cooperative union. Government of Assam started something, some industry, it went into loss whatsoever. You claim for your salary. You come before this High Court. High Court says pay them the salary. The government goes to the division bench. Division says bench say pay your salary. The state went up to Supreme Court. Supreme Court by a reasoned order says nothing doing. So the learned single judge or division bench ought not to have entertained this claim. So therefore, all these two judgments are set aside and passed. However, while disposing of this judgment, the Supreme Court says it will be, the government will be at liberty to, if they wish so, they can pay. There is no writ of mandamus. Then you file representation. Again, it was not done. Again, you come to the High Court. Listen to me. Listen to me. High Court once again says that this is the Supreme Court judgment. Our hands are off. Close. However, what Supreme Court has said, that can be done, go to the register of cooperative. You have went to the register of cooperative society. That's all. Now, what kind of order are you expecting?
Yeah, that Supreme Court has said we may also add that will not come in the way of the state government formulate any scheme for extending any relief or benefit.
Okay. Is there any mandamus to formulate the scheme?
Yes.
Where is the mandamus?
When some fund was released by the Section number 5 Lordship for revival of the school activity.
Hmm.
And it is Lordship, I will think next whole Lordship.
That is for revival, not for payment of your salary.
Yes, revival Lordship,
Not for your salary.
revival.
So if it revives, you can get that. Is not, we cannot now enter into this matter. Instead of getting an order, take a liberty, withdraw this and to approach the government in terms of Supreme Court's order and in terms of this court's order dated so and so. Otherwise, this is a case where a cost to be imposed on the lawyer for giving wrong advice to some helpless poor people.
Therefore, engage Lordship.
I am not saying about you. I am not saying it. Cost should be imposed upon the lawyer. Huh? Withdraw it. The learned counsel for the petitioner. wants to withdraw it and to with a liberty to approach the competent authority for redressal of their grievances as may be permissible under law in the light of the judgment passed by the Honorable Apex Court dated Apex Court dated judgment of the Honorable Apex Court dated
March
17/3/2019 passed in civil appeal number 6492 of 2022 and this court's order dated 6/8/2018 passed in WPC 5232 of 2012. First of prayer stands allowed. Accordingly, this writ petition stands closed. List petition stands closed on withdrawal with a liberty.
But the Supreme Court has granted them liberty to approach the.
That is why I say in terms of the Supreme Court. You are Mr.
RB Goswami
R.P. Goswami
or
for
Miss MD Bora for cooperation department.
for cooperation. And you are Mr.
Any
N.S. Leskar for application.
Sir, Miss MD Bora's name may be recorded.
MD, is she here in the court today?
My lord, due to some difficulty here.
No. If she is not here,
On behalf of
okay, Mr. Goswami on behalf of M.
apply.
Mr. Lordship,
Yes.
better relating the compassionate appointment.
Hmm.
Because it's a few days back and Lordship had asked that whether I read to answer the query was posed by the court before,
Hmm.
an earlier occasion.
Hmm.
Query was that there was 17 vacancies
Mm,
and one that is our name was sent by the DLC. So the court had asked for 5% is the total cap for compassionate appointment. And out of
please, this
17
matter after 3 weeks on a date to be fixed by it. Will not dismiss it today.
Lordship, I had brought an answer if just within the
You want to answer, but you must be ready to get the answer from the court also. Option is yours
Lordship,
after
my
3 weeks. Yes, Mr. Bora. Instruction received, affidavit is to be filed, affidavit file. Affidavit file, yes, affidavit file. Under Secretary of Panchayat and Rural Development.
In this case, one of the basic grievances of the petitioner is that, my lord,
Hmm.
department has not submitted this proposal before the deal. So until and unless they submit before the deal, so that cannot take it. Although the person died in 1996.
Yes.
Yep.
Yeah. I tell them, who is not well?
The conducting council
Who is conducting council?
until the court advocacy.
Okay, it is submitted to learned council representing the petitioner is indisposed today. Accordingly, prayer for adjournment is made. Prayer stands allowed. Please support. Ring it. Yes, madam.
Notice was issued to my lord on 1/10/2019. It's like for
snap, just 4 times. Snap. And every time order pass. But why?
Convention died in 2009. And 2 times SLC has rejected. Annexure 12 and Annexure 12 and Annexure 13. On their
Manoj Deka, why have you not recommended?
My lord, it is known to them, my lord, all the time, lordship, honorable court.
You cannot behave like this, Mr. Porajoli, maybe 96. Give us the reason.
detailed information has not been received. Only
Can an order be passed like this? You are not monarchs. Not recommended by SL.
reason is that, my lord.
Where is that reason? Where do you get the reason?
Detailed information has not been received.
Uh-huh.
In first,
So detailed information is not received. Can that be a ground?
I have to take in what that was the
Okay, Mr. Porajoli, learned counsel for the petitioner, grace for and his grant. We will not, whether she'll get or not, that is a different issue. But we will not
reason.
allow this kind of behavior by the state instrumentality. Because this is against the constitutional mandate of Article 4. As simple. You are not monarchs. We are in a republic guided by a constitutional philosophy. Maybe 2009, we may give her 20 lakhs of compensation for this. May not get a point. This is not the way to behave. He is a responsible officer. We may ask for department. Give a date. Yes.
The petition died on 31 1 and 10.
Hmm.
Then on 55 3 2010, he applied for appointment of compassionate in a plain paper.
Hmm.
Thereafter, on 31 3 2008, submitted another website format addressing the petition and associated the DFO wildlife system, Western Assam wildlife system at Dolabad Test. Thereafter,
Hmm.
it was forwarded. Then the petitioner was asked, asked the DFO to submit a report on financial status of the applicant. That was submitted on 18/10/2014. In the report, along with other two cases were also submitted regarding the financial report. And thereafter, there was no comment. Now that they have stated that the case was placed before the SL without being the DLC, and it was not considered as because for want of vacancy. In the affidavit they have said. And thereafter the other cases which were after 2011 were placed before the DLC and were considered as somewhere appointed. But third case of considered, the reason given is that for want of vacancy, SLC has taken. That's not the DLC. Like, in para 4 of the affidavit, it was filed by the respondent of the deputy commissioner. Para 3 it is written. In para A 3, it is due to I'm reading the para 3. That in the aforesaid content the deponent takes that state level committee meeting held on 14/1/4/2014, 104 numbers of candidates were recommended for appointment or completion ground against vacancy years 1996 to 2020, as per the guidelines issued by the government and directions of the Honorable Guwahati High Court by the order dated 6/8/06 in the number 6875. The state level committee in its meeting held on event considered the case of the prisoner but did not recommended her name for completion at appointment due to want of however, as
Where is the minutes of the meeting on 1/4/2015?
Is not an act.
What is this? Mr. J.K. Parajuli, Learned Counsel for the petitioner, submits that though a specific statement has been made at paragraph 3 of the affidavit in opposition that the case of the petitioner was rejected on 1/4/2000, rejected in the meeting held on 1/4/2015. 1/4/2015. However, such minutes has not been annexed with the petition. Yes, Forest, no, not Forest. This is by the affidavit filed with the ADC.
here they have annexed of the meeting held on 9
I do not know what are you doing for this.
it is included my the next affidavit filed by the for 5 and
Who is respondent number 5?
the dear follower.
What is that?
Affidavit is in the last page of the affidavit.
Pankaj Sharma.
Yes, sir.
This is 9/12.
Yes, sir. A meeting of state level committee.
No, this is 9/12.
Yes, sir.
What is the content of 9/12? We are, with our limited knowledge of English, we are not understanding anything. What is 9/12?
Minute was held on 9/2015, where applications from various states have been considered, Lordship. At last,
Application form?
from 2000, that minute that I just have to pay the 2000, most of 2011, 2011. we
Under
consider-
what authority of law you are considering from 2011?
Because there was, since there was,
So now we'll
one-
allow you to consider what 2000, everything. You cannot have double standard. Somewhere you will come, no, it has lapsed its post. Somewhere you will count for in the 2015. Even we have seen that recently we have sent series of names.
Right. they have stated that 2009 cases are last para 4.
Hmm.
The remaining cases 38 and 44 numbers of applications for the year 2009 and 10 respectively has been considered by the SLC and decided that more than 6 to 7 years have passed now. These cases are no longer fall within the considerable period for completion. Hence, these
Now, how can then 11 fall within consideration? It is 2 years.
2 years old.
Huh?
There's a bunch of minutes that I like to produce that a lot.
Problem is this, we are every day now from onwards next Monday, we are imposing cost in this situation. You will file an affidavit, annex something which are absolutely irrelevant, and when court puts question, you will say, I'll file an addition. So pay cost for the wastage of time. Is not it? Two questions are put, matters are adjourned. Is it the readiness of lawyers? Wastage of criminal wastage of judicial time.
It is that is different from that taken by the deputy.
That is what? Two difference then. Because we may say that appointment at this stage may not be given, but we will under public law remedy, we will fix a compensation. It will start from 15 lakhs up to 50 lakhs with a liberty to the petitioners to file a civil suit and get more damages if they can prove. Pay them. Mr. Gogoi Learned Counsel for the Forest Department seeks some time to file an comprehensive affidavit in view of the contradictory stand taken by the district administration and the forest department. Full stop. Prayer is allowed, list according. After 2 weeks. The departmental proceeding, this order of dismissal of the petitioner dated 14/2/2018 is assailed primarily on the ground of non-service of notice as regards departmental proceeding as well as non-furnishing of inquiry report. Full stop. Affidavit file.
Affidavit file, my lord, I have also
Though an affidavit has been filed, records are there.
record for that.
Though an affidavit has been filed, records are also with Mr. Borpujari. List this matter for hearing on evaded. Not these are not the cases to be taken up at 3. The date there will decide it. Admission here. List this matter in for admission hearing on
Lord, can it be sometime later, madam? 5th of March, 14th of March. and
14th of March. As fixed item.
So you can decide.
Decide it.
Everything is there.
If notice is served, then one aspect, if inquiry report is not furnished or furnished, that is another aspect.
Lord, if is ever, I need not spell out. I'm obliged.
Departmental proceeding not at 3 p.m. on Friday.
I will satisfy.
He is seriously ill. Mr. Sutia. Yes, Sutia, what you say?
Only because of this item, my lord.
We are the amicus here.
No, my lord. My lord, we have verified it, my lord.
Huh.
We have given in your computer also, my lord. Our instruction. Copy people.
Give it to him.
Yes, my lord, he say, my lord only say,
Hmm.
I can only say this is a fact. Lordship will compare it.
Okay.
If I tell everything, they will again, by modifying it, my lord, their own factory, they will produce so many certificates like it.
Who will produce? Okay.
It's made in their own factory.
Okay.
If I go through all these things, my lord,
Okay.
he will have to face.
What you say in person?
Not the fact, my lord, this is the answer. Put it. Yes, sir. This is my lord, lordship kindly compare it, my lord.
According to you, these are the original. Copy of original.
No, professor. Oh, this is, we have given the instruction, the original one we have collected from our colleague in the office. At that moment, these are the certificates.
You are Samsul Haq Borbhuya.
Yes.
This is something different. Thonbor Rabha.
So yes, it is a way example on.
Okay, example.
Example, at that moment, 1977, what was the malat, physically malat, what is the malat certificate is there, specimen of this certificate. And I have found in so many cases from Hailakandi and malat, yeah, Hailakandi and Korimgod district. So many cases are found. One case CID was directed to inquiry.
What is this office number 013916?
All are
What is the certificate against this?
number is same. Only
We
the
want the certificate against 013916.
01,
3916.
this is their certificate.
No, this is their certificate. What
Yes.
is in your record against this?
Yes, these are the certificate they have made, my lord.
No,
in their
no.
Own factory.
No, no.
Not-
They have made their own factories.
Yes.
You have given a certificate which belongs to one Dhonbor Rabha.
Yeah, Dhanbodaba is
In
the
Dhonbor Rabha number against also there is a number.
number.
So this is an unique number for against the specific certificate. So there must be a certificate against the 013916. I want that certificate. What is that certificate in your record?
Apart from that, my lord, what the policy, this certificate, what the policy, may I read it or I disclose you all this one.
No, no, you read it, no problem.
That is problem, like, we will file a FIR against him, my lord, because he will have to face the bill. Because it is, my lord, very, my lord, bad things, my lord, because it we will have to eradicate this ill motivated person. They are doing it in their own factory and they are blaming it. In the last occasion, we produced the record. Lordship asked them to see the record, but did not dare to see the record. They only sitting over the matter 100% and this is correct. That is their ballot. If I say something, my lord, the Sankoda, what Sankoda written, it will broke it. On the Mugudo, Kondo, that is the on the Mugudo, Kondo, Papa Buddha, Janoko Hiro. This is very important thing that is happened. What is their conduct? The petition. We are producing all these things. Even our examination is going on, my lord. In spite of this,
Okay, we'll give you some time. We'll give you just see, Mr. Sutia. If they have committed something wrong, they will have to face the music.
yes,
There is no quarrel on that.
yes,
As a courts of law, our anxiety is that somebody should not suffer for not committing any wrong. At the same time, we know our limitation in judicial power. When there are disputed questions of fact, we cannot enter. But we want you to file an affidavit making this statement that has been written to you by the Board of
Secretary.
Secondary Education Assam. Okay, that you have given it to me. Only that statement. We want an additional
yes,
affidavit, with a statement that
that is not genuine.
no, that statement is there, and with a statement that this 30139 what is 013916 and what is actually 022591.
Oh, serial number.
Huh.
This number maybe his certificate, because maybe tell it. But I will go.
No, you will have a certificate against this 013916. Isn't it?
Yes.
There are two aspects. That certificate says he has failed. Because this there is a very importance of this number, office number, 013916. What is your certification against 09013916? And what is your certification against 022591?
Yes.
You have an admit card. In that card, the age must be according to you. This has been manufactured, isn't it?
Definitely.
So that is what you say, that this is 013916. Actually, what is 0916? And a copy of that. This is, we accept for the time being as a fraudulent, this, that. And also 02591. You make a statement, these are fraudulent. Actually, these two numbers,
022551.
022591 and 013916. Just write it down.
Okay.
09013916 is the admit card in respect of Samsul Haq Borguya, and 022591 is the certificate, high school, HSLC certificate of Samsul Haq Borguya. You are saying these two documents are fake document,
fake.
and in addition to, you say that actually in this number, this was the certificate, this is the copy. That's all. Then we will not go into all these facts.
Now, beyond this, other thing is also there, man. I will explain it.
No, other things will, if you make a statement, other things will not even go, will say that law will take its own course. Beyond that, we cannot. Beyond that, we cannot go. We cannot determine whether this is right or wrong.
Yes.
You are right or he is right. Then we'll end the matter there.
Yes.
Okay. Pursuant to disputes order dated 1/2/2023, Mr. T.C. Sutia, Learned Counsel, submits that the board has verified the records and would like to file an affidavit stating the actual state of affair and regarding the genuineness of the original admit card produced by the petitioner under office number 013916, and the genuineness of the certificate, high school living certificate, pass certificate, examination pass certificate dated 27th of June 1977 under number 022591. Under number 022591. Accordingly, he prays for an adjournment. Prayer stands allowed. Please this matter on 12th of March.
12 months, okay. Before that, I can.
If you can do it, since you have said that you have some
Yes,
exam.
examination is going on.
Then when?
12 months.
12th of March? 12th of March. The original
He kept-
certificates produced by Mr. Dotto is returned.
No, my lord, okay. It should be kept your own record, man.
Okay. Are kept on the safe custody of MS M. Chaudhuri. Chaudhuri? Chaudhuri. Full stop. The court master.
Our instruction may be written.
Huh?
Our instruction
Okay.
may be.
The instruction furnished by Mr. Sutia is kept on record. Don't open up.
Obliged.
Okay, hard it.
The part.
Learned counsel for the petitioner MS. A. Begum submits that his meter has become infructuous. Accordingly, the writ petition stands closed. Writ petition stands closed, being infructuous. Interim order, if any, stands vacated. Mr. Ardor is present, representing the respondent.
Yeah, please, sir.
Yes.
This case is selected and order passed. Kindly come to page 51.
Yes.
51.
What is the issue? Tell us quickly.
To Lordship, I was appointed in the year 1979
Hmm.
as a beyond.
Hmm.
Subsequently, examination that I appeared
Examination
in
held for what?
for promotion,
Promotion to the post of?
post of LDA.
Hmm.
From grade 4 in 82, I qualified, I passed SSLC. Then I was promoted to LDA in 90. After the service book was prepared in 1992. In the service book, my date of birth is recorded as 1152.
Hmm.
Subsequently, one gradation list was published. In that gradation list, also my date of birth
What is
was
the stand in the affidavit?
affidavit was it. They didn't consider my admit card, my SSLC certificate. They are not considering that, and they are taking a standard since the inferior servant in grade 4. My date of birth was recorded as 1955. So they didn't consider.
What is your date of birth in terms of your matriculation certificate?
1190.
Where is that? Where is your service book?
Service book is in page 30.
My lord,
30, page 30.
before my lord further continues, I just want to bring it to notice. My lord, I was once the standing council of the Plains State Corporation. Now Mr. A. Sharma, Mr. Sharma is the standing now almost a year.
This is a to
corporation.
that corporation. Name is shown.
His name is not shown.
Okay. Registry to list this matter showing the name of
Sharma.
Mr. A. Sharma, learned standing counsel for the
Plains State Corporation.
Plains Type Corporation. Full stop. Registry to delete name of Mr.
No, I will remain for my little department.
Okay. Okay.
For department, government I have to.
Okay. Okay, please this matter on 5th of March.
May period.
Yes.
My lord, on 16/8/2023 matter.
Hmm.
The respondent number 1, 2, 3 are asked to produce.
What is the matter?
Matter, my lord, the petitioner is the my lord, the wife of the my lord, respondent number 4,
Hmm.
who is a my lord, central government employee
Hmm.
under CRPF. Her marriage was solemnized in 1998, and in 2008, my lord, both are separated and started living separately. During the my lord, this period, my lord, the petitioner filed maintenance case under 125 CRPC, and the matter or my lord, proceeding completed and maintenance was allowed. In that proceeding, my lord, the respondent never said that the my lord, he has divorced the petitioner by any form. My lord, kindly see page my lord, page my lord, page 28, my lord, next 3. The judgment of-
Is
page my lord 28. Judgment of the my lord, learned my lord, trial court matter.
is 20.
8 to 8. The my lord, operating part is page 29, my lord.
What was this for? 127.
My lord. On Thailand, my lord, 2017, but judgment was passed on my lord 18/6/2019, my lord. My lord would come to page 30, my lord, 30.
Hmm.
My lord, the first, my lord, paragraph, my lord, paragraph C. The first party, substantiating her claim, deposed as the PW1, that second party is her husband. Then you look at second paragraph. Second party, that is the respondent number 4, as DW1 stated that first party is his wife,
Hmm.
and he has another wife. Then my lord, second wife, my lord, second wife married solemnized in 2013. My lord, this paragraph, my lord, third line, my lord. He solemnized marriage, second marriage in 2013. My lord, third line of second paragraph. My lord.
Hmm.
Then my lord, paragraph 7, my lord.
Hmm.
From the above is clear that first party is the wife of the second party, who is not yet wife.
Hmm.
My lord, after that the petitioners came to know that her name was removed from the my lord service record of the petitioner, petitioner number 4, my lord. So my lord, she filed an application before the my lord authority to include her name, my lord. Kindly see, my lord. Thereafter, my lord, she was informed that my lord, kindly see page page 47, my.
Hmm.
Page 47, the petitioners were informed by the my lord, authority of the my lord, CRPF, my lord, commandant. In this case, my lord, stated that the my lord, initially the name of the petitioner was included in the service record as the nominee of the respondent number 4.
Hmm.
Then subsequently her name was removed, and in her place, the mother name of the respondent number 5 was 4 was included. Then my lord, next page, my lord, page 48. In this notice, also informed that talaknama was my lord, submission of certificate of talaknama.
Hmm.
But that talaknama never informed, never placed before the my lord petitioner or either informed to the petitioner, my lord. Then my lord, kindly see, petitioner also filed another application, and pursuant to that application, my lord, annexure 8 page, my lord, 51. The my lord impugned order was issued,
Hmm.
where my lord, it is stated that the matter has been inquired and explained at this state has been obtained.
Where is that?
My lord, page 51, my lord. Page 51. My lord, after inquiry, my lord,
Now, what do you want?
no, my lord,
What is the writ we need to be
my
issued?
lord, my prayer is, my lord, my name may be included in the service record, my lord, as a nominee of the my lord.
To do that, what should be our satisfaction?
My lord, because talaknama never, my lord, communicated.
No. That is a fact.
My-
What kind of satisfaction? Because we cannot pass orders on the basis of the facts. We must have a satisfaction that this is your right,
My lord.
and this right has been violated.
My lord,
Something. Now, to do that, we will have to first declare that this this talak was a nullity.
My-
Isn't it?
my-
And since talak is a nullity, the employer was wrong in deleting your name from the service record and giving the pension to the second one. Now, how the writ court will decide that this was not served upon it?
my lord, he never asked any
No,
further
understand. This is your argument.
My lord.
They say that it was received. The employee was satisfied that talak was complete. Now to reverse that finding, evidence is required.
My lord, no endorsement has been produced, my
Huh?
lord. No single document has been produced that the petitioner received the my lord, talak fine, my lord, never produced. And because my lord, the impugned
You
order,
want to
my lord, is
say,
a contrary to
so
the,
you
my
want,
lord,
so you want to say that in exercise of our jurisdiction, we will have to first determine whether this notice was served or not.
Well-
Isn't it?
Well-
Then we will have to make a declaration that no notice was served, so therefore this talak is bad.
Well-
And consequently, this should be the order.
Well-
Isn't it?
Well-
That we have seen notice has not been served, and therefore this talak was not complete, and therefore the divorce was bad, and accordingly she is entitled. She cannot. This divorce is bad. Therefore, she remains to be first wife. Accordingly, in terms of service rules, she will be entitled for the pension. If you say this course of action is permissible under law,
second marriage cannot be permissible. It is my lord, contrary to the my lord, rule 15 of the Central Reserve Police. Code.
no, there is no quarrel on there.
But-
But his employer are satisfied that there is a divorce. There is no bar on having the second marriage after divorce. Any bar in the service report that once a serviceman is divorced, he cannot marry for the second.
Divorce must be in a proper procedure.
That is what we know.
Lord,
So what is the forum to decide whether is a divorce is a right or not?
kindly see some judgment matter. Our honorable held that before divorce matter, reconciliation is necessary. That reconciliation never be not never be asked in any petition matter. And after the maintenance case, he filed.
We understand. You are absolutely correct. Can that course of action be done in a writ proceeding? That is my simple question.
In this regard, my lord,
Take your seat, mister. Who has asked you to stand up?
my lord, my name was deleted from the service book, service record without the ballot information. And without providing any notice, they cannot see that. Can you see the record? And no opportunity of hearing was given to me before deleting my name. No notice was given, my lord.
Gogoi.
Lord, rightly pointed out regarding the jurisdiction part, Lordship, so that Talaki Ben can be, Lordship, declared null and void by this liable under the jurisdiction. If Talaki Ben is declared.
Now, what is your responsibility? Suppose a person comes and says, I have given talak.
Lordship, the particular person has submitted a document, registered document, as well as to Talaki Ben. Talaki Ben also submitted, and Lordship, the document where they have marriage was registered, that also submitted. But Rule 15 says that in the living of the first wife, you cannot remarry it. And that divorce was, Lordship, as per the Talaki Ben, it was in
So they
2013.
presume that since the marriage was registered, Qazi might have is satisfied that there was a divorce.
Even Lordship, Talaki Ben also 2013. Marriage registration certificate 2015. If Lordship, the marriage registration certificate was Lordship after the Talaki, before the Talaki Ben, then Lordship, Rule 15 will Lordship cover. He cannot lodge. Even the service should be dismissed as per the honorable court order.
Recent judgments are also.
Yes.
Day before yesterday, there is a judgment.
Lordship. There was the validity. Validity part, Lordship, my opinion have
Come prepared. Come prepared. We might have a sympathy for you, but courts are not run on sympathy. That will be a law that the retreat court is declaring a talaki ban was not properties and therefore this was not a divorce in the eye of law. Our language should be like this. That is, in view of these are the conditions for talaki ban, these are not filled up, then we'll have to have a witness box here. We'll have to ask him how you have served it. He will produce a certificate, registered certificate. He will prove that it was not returned, so it was presumed. General Clauses Act. Then we'll have to cross-examine that this is not genuine certificate. Isn't it?
In the proper forum, he has a case.
Yes, he has a case. In proper forum, he has a
Yes, because Lordship, Talaki Ben was not endorsed by the court, Lordship. As per the Honorable Bombay High Court judgment, Lordship, when Talaki Ben was registered, Lordship, it should be endorsed by the court. He has a case, Lordship. But here, this jurisdiction, Lordship.
Here is the point.
Communication is
Here is the point.
talak.
Rest is up to you.
Lordship.
Here is the point. If you can, without any dispute, if you can show that procedure has not followed, yes, we'll go ahead with the judicial review.
I just indicating.
If that is the provision, that this is a certification is required, we'll ask him show us the certificate.
Lord.
If that is
Lord.
not there, that is gone.
Lordship.
We'll send it back to the
Lord.
authority.
Lord.
So therefore, you'll have to argue that. I have never received that cannot be a ground.
Lord.
If you say that this is the procedure and there should be a court's recognition,
Lord.
like an will will not do. If you say that a probate is required,
Lord.
this is the probate,
Lord.
then we need not go for a determination because a court
Lord,
has
yeah.
given a certificate.
Lord.
If he says that no, I don't have any certificate, meaning thereby procedure has not come.
Lord.
Matter ends there. But you cannot say that there was no proof, I have not received, these are disputed facts, we
Lord,
cannot
that
declare on.
part, Lord.
So here is the point. Take help of him.
Apology.
Highly obliged.
And Mr. Counsel, when court is deliberating, don't jump up. And don't think that court will take a view in anybody's favor. Court will give a patient hearing to everybody, then we will also make a return. These are the interactions. Isn't it? These interactions, I'll ask 3 questions, he will answer 5. We'll deliberate, then only we can understand. Don't think that we are expressing some views, meaning thereby it is allowed or dismissed. We are always open till we dictate the order.
Highly obliged.
Else, probably because লিখিত আদি সকল আল্লাহ দিবেন procedure required law in this case. Yes. Gogoi, not a case for Friday. What do you say? We have posed certain questions on last
Lord.
occasion.
Lordship,
See, admittedly, it's a mistake on your part. Counting, back counting.
Lord,
No quarrel on that.
Lord.
But
And also he is the custodian, Lordship.
no, she is custodian, that is fine. She was not initially custodian.
Okay, later part, Lordship.
She entered, she submitted a certificate.
Lord.
You did something wrong.
Lord.
Okay? But end of the day, fact remains that she is aware of her actual date of
Lord,
birth.
Lord,
She continued, she became principal,
Lord.
she exceeded the date.
Lord.
Thereafter, she retired.
Lord.
You now find it out.
He-
Now the core question is, in absence of any fraud
Lord.
or misrepresentation on her part,
Whether we can,
whether you can make a recovery.
Lord.
Now, law is well settled
Lordship, Lord.
that what is that judgment, Prasad and all.
Lord,
Law is well settled.
Lord.
But law is also silent. What will happen in such a case where he or she herself is aware and taken and kept silence to take advantage?
in Unyal case it was decided. I will place it.
That's
In Unyal case.
That's
it was decided.
okay.
I-
Not a Friday case.
Lordship, Lord.
That's why we want you to be here.
Lordship, Lord. I will be here. I will be here.
Huh?
I will be here.
Address properly.
I will be here.
See, 2 part here. One is there is admittedly no question of any manipulation.
Lordship, Lordship. There is
Nothing. It's a mistake on the clerk at that point of time. Back counting. He was like me only.
Lord.
Very bad in
that is
very bad in maths.
that is not there. Lord.
No, I am bad in maths. So he miscalculated 1 year, exactly 1 year.
Lordship.
1 year or 2 year?
So without you 1 year.
1 year. Exactly 1 year.
Otherwise also there is an endorsement also that Lordship. She should be retired in so month, Lordship. After that also she is continuing more than 6 months.
No,
June. That is also there in a service book, Lordship.
so and service book.
Service book, Lordship. I have the copy, Lordship. I have the complete scan copy. I have origin.
Okay.
Oh, Lordship. Lordship.
Okay, that because Mr. Medhi said that they have returned it.
They have returned it, Lordship. It was also sent to our office, the original copy, Lordship. Somehow it is misplaced, but it was completely scanned by the office, Lordship.
Okay.
It is there, Lordship.
Okay. Mr. Gogoi, learned counsel for the higher education department, submits that he is ready with the scan
Lord,
copies
Lord.
of the service book of the petitioner. However, seeks some more time to
Lord.
address this court
Lord,
as he has been asked to appear in this court
Lord.
under the last order only.
Lordship.
Full stop.
I'll-
Accordingly, prayers then allowed. It will take a few minutes,
Lordship.
20 minutes. When Mosumi, because we have already
Lord,
more or less we have recorded the fact.
Lordship.
20 of this month, 28.
Lordship.
You'll give the judgment.
Lordship.
So we want a proper
Unyal case, some distinction is there, Lord.
Okay.
Even Lordship, Rafiq Masji's three judges bench is there before two judges bench in 2014. That also,
So we want to understand what is, see, this is the position in this case. Here is a position is that she was at the entry time, she did not have any intention.
Lordship,
She did not have any intention to exceed beyond her date of
Lordship, it
retirement.
is there, it is there.
What happened is she became the principal.
Custodian Lordship.
She became the principal. She is aware.
Lord.
Then she's thought, if nobody is raising,
Lord.
why should I?
Every
Let
part we have
me
to-
continue for one more year. But whether in a high position of a principal,
Lord.
in a college,
Lord.
her silence can be condoned in a retreat.
Lordship.
If it can be condoned, it will be condoned.
Lord.
If it cannot be condoned, what next? Her service is taken.
Lord.
Get another respect. So what should be the final outcome? Assist us.
Lord. Oblige.
You also.
Oblige.
Yes. Huh? You are always on name. Show the video. Ask them to look into if they don't have any faith upon their lawyers. Click here, escape. Good. Order Lolen. Okay. Very liquid. Click here. Record the name. That's
But these three petitions are being filed by the employees of Pachar Paper Mill and the.
Yes, that last, what to do?
Lordship, last query was regarding the provident
Uh.
fund. Thank you. Now, if we is taking care of,
Take care of it.
this is a letter of 2019, ma'am. Sent to liquidator, official liquidator, Mr. Kuldeep Verma, by the APF. And accordingly, we have submitted the accumulation statement.
Yes.
So far as I have submitted two documents, the minutes of the meeting held up with the presence of the chief minister, who earlier agreed to pay the PF amount along with all the gratuity funds. But later on, the first meeting was held on 28th September 2021. So Lordship, the para number 3, for assessment of the quantum of relief to be given to the workers and employees of HPC Limited, the following claims to be taken into consideration. It includes PF, gratuity, and pension full payment. So far as gratuity and salaries are concerned, we have received from the package. And later on,
That is the problem. These are creating problems on your right. Isn't it? A statutory body, statutorily, there is a process of liquidation. The liquidator can bound the state. Give that. Isn't it? There is a statutory body, PF authorities. They are also in the session of the matter. If we record all this, that may create a problem for you. You are going to two parallel authorities. If it gives you, it's very well and good.
so later on the next meeting, they said that they won't be able to pay because of the Supreme Court judgment. In 2022, one judgment was passed by the Supreme Court where the section 36 of the IBC has been clarified that the PF and all these amounts are outside the purview of the liquidation process.
Liquidation process, but they are taking note of if that has not been given to you, the new owner, they will get hold of the state of Assam. Isn't it? They are having statutory. We are not commenting anything. That creates a problem. Close it.
Yes, but only an observation may be given that this order may not come in the way. if
No,
they
we'll
give
say to not in the way in getting their due in terms of statutory due, salaries, etc. How many petitions are there?
Three.
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 Common order will do.
common order will do, but two orders will be common. The one order is pertaining to Nogao paper.
So in one case, it will be Nogao. In others, it will be Kachar.
Kachar.
Which are the Kachar?
Kachar is 33 WPC number 6330
6330 and
and
6468. Mostly, Smita. Kachar
6446.
paper mill and
46.
64
46
is Morigaon.
Nagaon paper.
Nagaon. Which are the Kachar?
Kachar 6468.
6468 and 6330.
Yes.
This is Kachar, huh? And 6446 is the Morigaon.
paper.
Jagi Road. Third, Mr. Biswas, Learned Council, representing the petitions. Also heard who will represent? Give a list. Union CGS is also there. Mr. ASG, who will represent?
A Gayan.
A Gayan. Who is for P. Chaudhary for whom?
Liquidator.
2 as well, 2 and 4. 2 and 4. The petitioners are employees of Kunbatut Nagaon, Kunbatut Kachar. Okay. Nagaon/Kachar paper mill under respondent number. Nagaon Kachar paper mill. Okay.
Originally, it was respondent
Okay.
number 3.
Okay. The petitioners are aggrieved by non-payment of salaries, wages, and retirement dues. Retirement dues. Full stop. What have you received? Salaries you have received.
Salary
During the pendency of this writ petition, in terms of supplementary grant, in view of supplementary demands for approval of supplementary demands for grant, the Union of India has paid the arrears of salaries of the petition. Isn't it? This was by Union of India, not under liquidation. Isn't it?
this is in the liquid.
Okay. Okay. Then, in the meantime, the aforesaid 2 paper mills were under process of liquidation in terms of IBC. It is submitted that during the process of liquidation, arrears of salary has been paid to the petitioner. And arrear salaries and gratuities have been paid to the petitioner. Full stop. However, the provident fund dues has not been paid till date. Full stop. So, state of Assam, full stop. In the process of liquidation, it is stated, it is stated at the bar that the state of Assam has taken over the assets and liabilities of the aforesaid organizations under liquidation. Full stop. It is also brought to the notice of this court by Mr. Biswas that in terms in a minutes of meeting between all the unions of Hindustan Paper Corporations Limited within bracket under liquidation held with the Honorable Chief Minister of Assam on 28th of September 2021. A decision was taken. Where is the decision?
The minute of the meeting.
Decision.
Paragraph 3 for assessment of the quantum of
A decision was taken for assessment of the quantum of relief to be given to the workers and employees including Provident Fund, however, in a subsequent meeting held with the Honorable Minister on 11th of May 2020, so far relating to payment of Provident Fund dues. Is that it?
Yes.
Where is the decision?
Well, at the third paragraph,
Provision of
Government of Assam had held a meeting with engineers and
will get the job, will be not get. Where is that? Paragraph 2, 3.
paragraph third.
Initially it was agreed. Okay. Come on. Now, where is that?
Well, it starts with Government of Assam. It's 11th May 2022 minute.
11th of May.
Government of it
Acha,
starts with government.
however, in the meeting dated 11 May, it was decided that in view of the determination made by the Honorable Apex Court in Civil Appeal number 5910 of 2019,
Quoted
reported in
2022
2022
7
7 SCC
54.
540
The case of Sunil Kumar
Sunil Kumar Jain versus
and
others versus.
Sundar Ray Bhatt.
Okay, just Silo. Wherein it was held that gratuity will not be made from the liquidated amount, the state of Assam,
Paragraph 20,
paragraph
24 of the judgment.
State of Assam, there is a change in modality with the relief package. The change in the modality of the relief package proposed by the government earlier made on 28th of September 2020 was done. Full stop. On a query posed by this court on 7 to 2024, Mr. P. Chaudhuri, learned counsel representing for the liquidator, has submitted that the Provident Fund Commissioner is in the session of matter so far relating to payment of the arrears of Provident
Yes.
so far relating to the payment dues to be made to the petitioner which accrued during their service. Full stop. In view of the aforesaid and in the considered opinion of this court, when the Hindustan Paper Corporation is already under liquidation and payments are being under the process of liquidation, and at the same time the statutory authority under Provident Fund Commissioner are looking into the matter of non-payment of statutory Provident Fund dues, nothing survives to be adjudicated in this writ petition. Accordingly, the present writ petition stands closed. However, while parting with the record, it is made clear that closure of this writ petition shall not be treated as any bar for the petitioner to claim or approach to claim their dues before the statutory authorities or claim for those dues which they are statutorily entitled, or to approach any competent authority for redressal of their grievances. Accordingly, this present writ petition stands disposed of.
Part of
तीनटा type में all disposed of. एक बन रखी थी minus submit. Okay, next case. Next लगेगा. Yes, Mr. Chaudhuri हुआ, Dev Chaudhuri हुआ.
But the matter, petitions are also faced with
behavior.
You need not come, will not keep CFE. I will hear him once again. Everything is gone out of the hand. He's the unlucky guy when it is.
Lordship, he is very lucky and he knows how to go about.
No, he's very unlucky so far relating to hearing of his personal method. So, and they more particularly in Discord.
In any case, if Lordship because any day,
Okay.
next week I'll not be.
Okay, you give it.
After March,
You cannot go beyond a month.
Next week I'll not be here.
We'll act on it. That is his proposal. Or at some point, please dismiss the further hearing on. We'll dictate on whenever you are present, or maybe we dictate on the next day. Give it. Don't expect anything on that. First, we'll decide that. Today I could do something on that, and we are listing it around 13, that matter. Then 14 is a holiday. So that is the program how we are doing. And by Monday, we'll deliver the other judgments. 3 judgments are there, we'll deliver. Friday is again difficult.
Let it be the week commencing
Monday, next Monday after Friday.
19th.
19th. 28th.
night from 13 on.
Oh, he is having a difficulty.
Yeah.
Okay, we'll fix it on Friday. Then adjourn. After all good thing happens. Okay.
Highly. Right. Let us go for Lakshmi put order Lakshmi can you see 5 to 2034.
Before going to Lavajima, let us see the order.
Lot.
Where is the order?
There is the IA 2030 of 2021. There is the order for treatment of matter for impeding the chief engineer. Because earlier was matter
No, forget about the IA. Let us tell the order passed by this court.
so for taking fresh steps. Second,
Oh, you are on fresh steps. We are on the order. Why you need steps? If it's a direct order, they are not implementing. We will ask the standing council.
Yes, my lord.
Why are you shying away?
My lord, page
And
eight,
is there, if there is nothing, why should you take a steps
my lord, yes, that
in
was
the year 2024?
page 8. Lord,
Page 10,
page 10 is the last.
operative portion.
Yes, my lord.
Yes.
Chief engineer was directed to my lord consider the promotion of the
Yes, irrigation.
Let my friend implement the new incumbent.
Will not implement. He may stick to implement.
2017 matter being on meeting and everything.
Are you having any relation with your client? Because he has been granted promotion. He will bring the instruction, will finish the application matter on Tuesday. Isn't it?
Yes.
Or you want to spend some more money
No,
taking steps?
man.
Then why are you asking that to take steps? Then there is a benefit for him also. Will record his name in a contempt without being engaged. Isn't it? Win-win situation. Hard. Mr. So-and-so learned counsel for the question. Thus, or the present contempt petition is filed alleging an willful and deliberate violation of this court's order dated 17/8/2016 passed in WPC 4253/2016. They generally comply this kind of orders. If batch orders they might have some problem. This kind of orders will come. The following direction was issued by this court. Paragraph 10, black mark 2, black mark. This contempt petition is pending since 2017. In the meantime, many officers who were responsible for implementation of such order has been retired. Full stop. The learned counsel for the petitioner has also submitted that he could not take steps for implement of new incumbents and he is having no contact with his client. Full stop. In that view of the matter, this court requests Mr. N. Upadhyay, learned standing counsel for the irrigation department to obtain instruction whether the aforesaid order has in the meantime complied with, and if not, the reason thereof. Full stop. Mr. Upadhyay has readily accepted such request of this court and submits that he may be granted a week's time, and week's time to obtain such instruction. Prayer is allowed. The learned counsel for the petitioner shall furnish a copy of the contempt petition to Mr. N. Upadhyay, learned standing counsel for the irrigation department. Full stop. Registry to release this matter on next Friday, 23rd of February 2024, showing the name of Mr. N. Upadhyay in the cause list. Lord, Mr. Upadhyay may download a copy of this order and may forward the same to the competent authority for his necessary instructions. Lord. Yes, you have taken steps but not served. What is the order? Where is the order? The present contempt petition is filed. Assailing. We will not allow, we are dismissing this. People. Assailing, alleging willful and deliberate violation of this court's order dated 17/8/2016, passed by this court, passed in WPC 3630/2016. The operative portion, the direction, operative direction is quoted here in below, page 8, paragraph 8. Okay. This contempt petition is pending since the year, this contempt petition is pending since the year 2018. Full stop. Though petitioner has taken steps, however, it is reflected that the competent officer upon which, up to whom notices were issued, has in the meantime left their office. left here, office. Full stop. In that view of the matter, yes, PWD, Nayak. In that view of the matter, Mr. P. Nayak, learned, this court has requested Mr. P. Nayak, learned, standing counsel for the education. There is a simple case. Commissioner was asked initial, it was her case was placed before the SLC. SLC says you are S barred. Okay, so your case is rejected. Now, court says S bar determination was bad. Therefore, that decision is set aside. And it says you place afresh and take it on merit, not on the age. It is in 2016. Might have already been completed. And direction was issued to the commissioner and secretary to place.
Yes.
Okay. So whether he has placed or any decision is taken, I think he'll be away.
Lordship, I will take it.
Okay.
But so far as this question is concerned, Lordship, the 2021 case, you already
Retired. That's why I have said.
prior to 2020.
Okay. Retired. Technical. Accordingly, this court has requested Mr. P. Nayak, Planet Standing Counsel for the PW Department. And Mr. Bora will not be there next week. Huh? And who is State Counsel? Ardhar. State from SLC. Mr. Ardhar, Learned Counsel, Learned Additional Senior Government Advocate to obtain instruction and apprise this court whether the aforesaid order has in the meantime been complied with, and if not, the reason thereof. Full stop. The learned counsel for the petitioner is to serve a copy each to Mr. P. Nayak, learned standing counsel for the PWD department, and Mr. Ardhar, learned additional senior government advocate. Okay, you give a copy to Ardhar and a copy to Mr. Nayak by Monday. By Monday is the date 12. Full stop. Thereafter, release this matter on
What time we are?
23rd.
2 weeks,
2 weeks, 23rd.
Lordship.
23rd. Today is Friday. Next Friday is the 16th, then 23rd.
Okay.
23rd of February 2025 for registry to reflect name of Mr. P. Nayak and Mr. Ardhar in the cost list. You give your copy, otherwise we have shortened your job. Otherwise, have to file an impleadment petition to the new. First, you will have to give a notice to the new incumbent. Then you will have to file an impleadment petition. Then we will issue notice. Then they will come. It is a long, lengthy process. Okay, so give 2 copies to them, and we are deciding what has happened. Please record. Yes, Sharma. Any- is it a- huh?
4 weeks time.
Happily granted. 21. Huh?
Some issues are there, Lordship. 4 weeks
Okay,
time.
Mr. N. Upadhyay, learned counsel for the petitioner submits that he may be granted 4 weeks time to file a petition of which. Prayer stands allowed. Please record.
Obliged.
No part heard matter. Yes, what was this? So many part heard matters on your pressure. Yes,
Part is sit for determining the concept of legality and validity of conformity. Term conformity.
we requested
Otherwise,
Mr. Borpujari to assist. Not today.
Otherwise, I have collected some materials. You may be pleased to fix this matter on a hearing day.
Okay. It's not a case for Friday. At a timeline of further hearing.
20
Please this
Yeah,
matter on. Mr. Borpujari,
My lord,
we have brought in so as per your confidence.
no, my lord, I am
Huh?
obliged, my
No,
lord.
you are busy, we know that.
No, my lord.
You and Nayak, we can only request. And Mr. Gogoi.
My lord, can it be on 22nd of February if it is not in
5th of March.
5th of March also,
Okay.
my lord. 7th,
7th of March. 7th of.
I am obliged.
Okay, thank you for your assistance.